What's up? What's up? What's up? It's Saturday, April the 18th. Welcome to another edition of Operation Wise Dome edition, should I say, episode? I don't know how we do this here, but either way, thank you for being here on today's Operation Wise Dome. If you're watching for the first time, hey man, y'all got to come in and get on in on Operation Wise Dome. It's amazing. We're having fun. We're making a lot of progress in the world today as far as people's rights are concerned. And hopefully, if you got any issues yourself, you can take care of them yourself as pro se, just by learning. This morning, what we're going to be doing today is another workshop. I love these workshops because we're going to be announcing a whole bunch of things that we've been working on throughout the week, a whole bunch of announcements, a whole bunch of issues. Wins, dismissals, the whole 9 yards. It's been really great this week on Operation Wisedome. And then just some other things as far as civil suits, maybe on my end and maybe on some other ends, as far as other people bringing their civil suits and what's going on. And first off, what I kind of wanted to start off on was last night. I think people in the Wise Dome kind of know Colin. He's come into our meetings a couple times, and he's in the Discord as well. He runs a YouTube channel where he kind of like reviews sovereign citizens or pro se litigants who kind of, I guess, don't do that well in court. And when I mean sovereign citizens, I guess their definition of sovereign citizens is a little bit different than ours because I guess people say that over time definitions change, right? Or words change as far as definitions are concerned. I don't know. Um, I kind of feel like they stay the same, or at least etymology, you go back to a certain point and learn where they're supposed to stay at. But I don't know. I guess other people have different opinions, and that's okay. But what I wanted to do is I kind of wanted to go through a little bit of this court hearing that we went through last night. And I don't want to go through all of it. It's 30 minutes. I might speed it up even a little bit. But and actually, I think I got it in the Descript so we can see the actual transcript of it. So I might do it like that instead of on the QuickTime. But how maybe you're not supposed to come into the court and try and present yourself. I think it's a little bit faulty here. But if anybody else watched that last night, how did y'all feel about it? I know I saw you in there, Joe. I know I saw you in there, Marine. How did y'all feel about the situation?
Joe, you go ahead, sir. You're on mute. You're on mute, Joe.
I appreciate it. Thanks for the reminder.
I got you.
Um, yeah,
Nice Bob Ross shirt, by the way. I love that shirt, dude.
oh yeah, thanks. Yeah. Hey, when you make mistakes, you turn them into birds. Anyway, um, yeah. So that guy definitely made some mistakes. He didn't have an opportunity to turn them into birds. I thought, like you said, Cam, the judge was honorable. He didn't stomp all over the guy. He didn't interrupt him. He let him speak. But I think that was probably just setting up a trap because the guy kind of put himself in the hole himself
Yeah.
with some of the things he said. Not knowing any of the court procedures and rules and that method. When you go into when you're at court, you want to know the rules and procedures that they're going to follow so that you can hold them accountable. And so when you go in there, like, okay, so, and I don't want to hijack the conversation, but
Oh,
I'll
you're
give you
good,
my
bro.
reason.
Do whatever. You're fine.
So when I went into court before joining Wisedome, I went in there very similar to that guy. You guys this is administrative nonsense. There's no crime. We're done here. Kind of leaving it at that, especially with traffic infractions. So, no filing, nothing. It's all just my words speaking, which is just going to fly out the window. Coming into Wisedome, I've perfected, and continue to perfect my record. Going in here with the mindset that my record is what's going to stand as true. And so I want to make sure that everything that is written is going to be applied at a court of law. This guy didn't do any of that. At least I don't know if he's even filed anything, but he went in there blind. He went in there unprepared, and doing it, making a ton of mistakes. And the judge called him out on it, appointing him some counsel, which is, just basically I don't want to say a death sentence, but expect a guilty verdict with maybe some, charges reduced or some fines reduced or something like that. Yeah. And that guy, Steven Tyler over there with his six fingers and his outfit. Yeah. Anyway, so the pro se litigant went in there unprepared, and really just dug himself a grave. Spoke a lot. and didn't hold anybody accountable to any of the charges or anything. Totally the opposite of what you do here at Wisedome. So that's my opinion on it. And so, yeah, it was, I yield.
Cool. We'll get into it.
Can we have Mr. Lee first, please? Mr. Lee first.
He's not in custody.
Oh, he's not in custody. Oh, I thought he was. Court calls the people of the state of Michigan versus Philip Andrew Liefers, case number 26819FY. Appearances, counsel.
Please roll for the people.
Good afternoon, Your Honor. Bernard Jockins appearing on behalf of the defendant, Philip Liefers.
So are you Mr. Liefers?
Are we on the record, Your Honor?
We are. Are you Mr. Liefers?
Can I say something?
Is it
Can I
Liefers
say
or
something
Liefers?
about this?
Yep.
So I'm curious on this. Last night we were talking. So again, this gentleman has counsel appointed to him numerous times. He even let Mr. Wiggins say, "Hey, are you requesting to be pro se? Are you requesting to represent yourself?" There's no requesting going on there. First and foremost, you need to understand your capacity and like actually grasp it. Secondly, I found it interesting. If you really wanted to, I kept talking about Corpus Juris Secundum, Volume 7, Section 4 last night.
Okay.
That right there, if you say that, you're making it illicitly clear that the attorney at law is an officer of the court.
Right.
I'm not sure that you grasp what, I just hope people realize Corpus Juris Secundum, Volume 7, Section 4, the attorney-client privilege, that's pretty detailed, and you again are submitting yourself to being a ward if you take on an attorney at law.
Right. Exactly. And then, of course, the attorneys, again, have a duty to the court
Yes,
that
sir.
is more important than even their client.
Yes,
Right.
sir. Yep.
Like
you.
it supersedes it all the way. So yeah, that's something that we realize. That's something that we know. And that's why, we try to take on all power that we constantly have, because a lot of the attorneys out here, like, we'll get into it. I want to even get into Robin's situation and how we have, like, we have certain people within Operation Wisedome that currently have attorneys, but then are still kind of, working with me on the back end to do research and development. And, they're like, oh, well, as we're in a meeting, like, oh, well, they just filed a bill of particulars. And then, he's looking at their bill of particulars in comparison to the bill of particulars that we made. And he's like, it's horrible, right? So, and these are paid attorneys, not public attorneys, public defenders. So it's just interesting across the board how many times now, especially in Florida, like I would say 70% of the people that are having issues are in Florida, literally, how they're paying these attorneys to do stuff, they're not doing anything, and then our people come through with all power, learn the knowledge, and then literally get the dismissal. It's just insane. So I don't know. But yeah, we'll continue.
I am Philip Andrew Liefers, being duly sworn, hereby declare my intentions to be a Michiganian national by birth, but not a citizen of the United States. I am here on special appearance, in this case, as authorized representative, beneficiary of the estate, Philip Andrew Liefers. I appear before this court without waiving any rights, claims, defenses, or remedies available to me at law, equity, or under trust or fiduciary law. I have my CPAS.
We can't really hear him.
Sir, can I get you to speak up so that
Yes,
so that we can get a clear record?
I have my CPAS. I have been working very hard.
Okay.
I missed that last night. That's what you guys were talking about.
Yep, that's what we're talking about. He stated he has his C-Pass, y'all. SEA, his C-Pass, okay? So I know there's like, kind of some theories out there in relation to admiralty and, law of the land and then law at the sea, and all this good stuff, going into those depths, which I've read about and I've probably forgot a lot about, even though I've read about it. If someone's got their C-Pass and they want to let me know where they got it from, please let me know. I'm trying to get that C-Pass too. And I'm not talking about SeaWorld, okay? Okay? But please, if anybody's got a C-Pass that is getting rid of all jurisdictions and making you, free and clear, let me know, like Liefers, because Liefers got it, he said.
Hard to understand and overstand.
I don't understand what it is.
A lot of things in the past.
I've
heard it recognized as CPAS.
No disrespect, just complete forwardness. I move the
Wait, say that again.
I said I've heard it referred to as a CPAS C treaty, but I don't know too much about it. But he said CPAS. He didn't mention the C treaty part, but It could
Yeah.
be the same thing. It might be something different, but I've heard about it maybe about a year and a half ago.
Man, write that down.
Certain,
Okay, so write all that down in the chat real quick, and we'll look into it a little bit more.
I'm on the road, but
Okay.
when I get to the office, I'll let you know.
Okay, cool. Put it in the chat if you can.
The court to
That's
take
cool.
judicial notice of the Michigan Constitution of 1850 and the United States Constitution of 1788. And your oath to it, sir. Yes or no, please.
The yes or no to what?
This is a copy of your oath of office, sir.
I don't take anything until the judge tells me to.
Bailiff, I'll take it.
Yes, sir.
Yes, that is my oath of office and has my signature on it from January 22nd, 2025. You can hand that back to him.
I move the court to dismiss this case per canon 2057.
Brought
which
in a
states
canon.
Any administrator or executor that refuses to immediately dissolve a sesta trust upon a person establishing their status and competency is guilty of fraud and fundamental breach of their fiduciary duties, requiring their immediate removal and punishment. Per the United States Constitution, Article 3, Section 2.
Now, right there, he brought in a clause. He brought in a canon. It's 2057. Okay, so he's trying to bring in some stuff that may apply, but y'all got to remember, this ain't the place for it. Right now, this is causing controversy. Okay, into the court because he hasn't brought it in writing to fully discuss, review, and thoroughly go over. Okay. Plus, he already has an attorney right now that's representing him. He's not pro se status. So for him to even start reading all of this into the record is really null and void. It has no, it has no effect whatsoever. Okay.
Why did they let him read it in if he's got an attorney? They
Because the judge is just honestly looking like he's being an honorable judge to allow him
Fair enough.
his right to speak.
Fair enough. All right.
I mean, this judge looks. I mean, throughout the whole thing, the judge was pretty honorable, bro. I haven't seen. There's not a lot of judges like this. Let's keep it real.
Clause
Right.
2 clearly states that when the state is a party, whether defendant or prosecutor, the Supreme Court has original jurisdiction. Supreme Court decision 1796. There every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellow man without his consent. Prudent v. Neely, 2 NC 338, 1796. And don't forget the law of the land, where the general misconception is that any statute passed by legislatures bearing the appearance of law constitutes the law of the land. The U.S. Constitution is the supreme law of the land. And any statute to be valid must be in agreement. It is impossible for a law which violates the Constitution to be valid. This is succinctly stated as follows. All laws which are repugnant to the Constitution are null and void. Marbury versus Madison, 5 U.S. 2 Crunch 137, 174, 176.
That's not bad right here.
No, he's got great. He's mentioning great stuff, like I say, but this isn't the time and the place, bro.
Yeah.
You need to bring that into writing in some form or fashion. Like right now, you're coming through with constitutional arguments. Okay, I'm going to ask y'all, how would you bring forth constitutional arguments?
A document.
Okay, a document, but what type of document?
Notice of judicial notice.
Okay, a judicial notice. What else?
I was gonna be saying an affidavit of facts.
Okay, you could bring forth an affidavit of fact in that. As far as affidavit of fact, you more or less want to be to your facts, your sworn statements, but you could bring it in as a judicial notice as part of the affidavit. What else? Anything else y'all thinking of?
Memorandum of law, supporting memorandum of law.
Straight up, a memorandum of law in
would
support
say,
of
yeah.
what? In support of what?
Of the Constitution.
In support of
An
in
debate.
support
The
of your,
Constitution.
I mean, yeah, that one can
Of course,
work. Yeah.
Yeah, but if you're gonna bring listen, if you're gonna bring forth a memorandum in law, it's got to be in support of another document.
Right. Yeah. Yeah.
So whether that be an abatement, whether that be a notice and demand to dismiss as unconstitutionally applied, because you're breaking down the elements of how that statute is being unconstitutionally applied to you, right?
Yeah.
He's doing this, but again, this isn't the time and place at all.
Yeah. I think I ended up when I filed a notice for the court to take judicial notice of law with the Constitution, Virginia Constitution. This was for my UPL case. I included a supporting memorandum of law associated with that.
Right. As you should.
So notice for judicial notice of law and supporting memorandum of law that supports your judicial notice.
Most definitely. Because again, that first initial document, you want them to be able to go through thoroughly, not too long, not too crazy, but then also give everything that you are bringing forth in support in that memorandum. Okay, let's keep going.
In 18.
Hey, gentlemen, and
Wouldn't the
everybody else, I'm
Constitution
going to
have
have
to
to get
also
out of
be
here.
certified?
Wait, what happened?
I apologize real quick. I'm just going to say, see you guys.
All right, brother. Thanks for coming in, bro.
I'll be back relatively soon. I appreciate you guys for your time. Have a good
All
rest
right,
of your day.
brother. All right, you as well. What was you saying? Somebody else had something to say too. I think it was Chris.
Wouldn't the Constitution also have to be certified too in order for it to be accepted?
That's a good. I don't think so. Why would you?
What
say
do you
that?
mean certified?
Yeah.
So a certified copy of the Constitution through the Secretary of State, or what is it? I think it's through the Secretary of State in order for it to be actual authenticated copy
Evidence
of the Constitution.
I think Chris is right, though.
I
Notice
don't
of it.
think so. I think that's going to really fall under the rules of the court. So you can reference, you could cite. It depends on how they want you to cite whatever you're bringing in. It could be a book. It could be a dictionary. It could be there's several categories. I don't think that you would need to have a certified copy of the Constitution, state or federal, to bring that in for the court to recognize it.
Me either, and I definitely think that the state is going to have a reference of the Constitution online somewhere specifically. So if there's a reference to it online somewhere specifically, what I would think is that you'd be able to just reference that actual website, print it off as such, and then that would be your validation, right? Because they're the ones that are releasing that. So it's like, well, you're putting me on notice by releasing it here on this actual website. That to me would be certified enough. I don't know. What do you think?
Well, so anytime that I've ever brought up the Constitution, judge says that the Constitution doesn't apply here.
Okay, now that's that's happened. That's happened to a lot of us. That means that's a court of limited jurisdiction, bro.
Yep.
That's an administrative court. That's nothing more than an administrative court right there, then, bro.
Exactly.
It's a kangaroo court. Yep. So, if anything, I would take that bitch up. I'd file to move it on up. If that's what they're saying on the record, and there's probably ain't even a record anyways, then I would move it up. I mean, me and Bob both went through Justice Kidd through the Salem Justice Court, where that dude literally on my own record said, the Constitution has no applicability here. And I'm just like, what are you talking about, bro?
Like, huh?
What? What are we doing here then, bro? So, what's up, Jack? How you doing, bro?
I'm good. How are you?
Doing well, bro.
I know I'm a little late, but seriously, like, how's your recovery coming?
Oh, it's going good, bro. I just pulled off. Well, we got stitches removed last week. And then they gave me like these bandages, these white little bandages that go over and they're supposed to just fall off as they fall off. And I just pulled them off this morning. Quick little other update is I got a shower chair. So like before shower chair, I was taking like bird bath type vibes and that sucked, bro. But now I'm able to get in the shower and literally let the water just run all over me. Listen, if you don't understand what it's like to not have a shower for a while and you have to take a bird bath, bro.
Oh yeah. Been there.
Go to jail.
No, even in jail, they letting you get a full bath, bro. A shower at least, bro.
I wouldn't even get in the shower.
Shit, I've been in jail. They gave me showers. But what I'm saying is like, never take for granted being able to take a full shower, bro. Like,
You're right,
bro.
The little things in life are just so much, bro. It makes me want to cry, but I'm not going to. Okay, we're going to keep playing.
Secured by the Constitution are involved. There can be no rule making or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. 436, page 491. The United States Supreme Court has repetitively held that any judge who acts without jurisdiction is engaged in an act of treason. U.S. versus Will, 499, U.S. 200, 216.
Now, the reason I think the judge is honestly letting all this come in is because dude's speaking, you know, he is bringing in some stuff that is valid. Okay. Is it valid to his case and in this situation currently right now, as far as procedure is concerned within the courts there? Not really. Would I bring this in just orally on the record? Not really. I think I would particularize it. If he's saying, oh, well, the judge in this would be invalid and it's invalid on this, well, what action has the judge made? what action has the court made against him to even bring this forward, right? He's bringing in a lot of things, but there's no particular actions in which these judges has made that would allow him to even, to me, bring this forward. So it's kind of weird.
S period CT period 471 66 L addition 2B 392 406 in 1980. I Cohen versus Virginia 19 U.S. 6 week 264 404 5 L edition 257 1821. 5 U.S.C. 556 B 557 and 706. Once due process is denied, all jurisdiction ceases.
Well, due process is still in process here. It seems like due process is being given. So, you know, again, making statements that are not really relevant to the actual situation in and of itself.
I got a question about that statement though.
Yeah, go ahead.
When would due process be considered denied? Like, at what time would you say maybe they start with due process and then they completely go off the script of what they're supposed to be doing?
Well, yeah, like if you're submitting any kind of motions or notices or anything like that, and they're just getting denied outright, or any requests in any form or fashion, whether it be discovery, formal written determinations, anything like that, as far as they're not answering, would be a violation of due process for sure. Because you have eligibility, or you have they have a duty to respond to you and to give you all of your rights. Now, I wouldn't even say just rights, but like they have a duty to operate within what you invoke, I guess, and bring forward. And if you don't invoke those, then yeah, I guess they could just, slide right through or right by. But once one knows at least enough to invoke said rights, duties, responsibilities, and things owed to him, then I think that's where it becomes due process violations. What were you thinking?
Well, now here's the thing: is in my federal court in Ohio, where the Ohio law says the arraignment and probable cause has to be on record, and it defines what on record means. Audio, video, stenographer, and there were other laws that they did not follow. And the federal judge in my 1983 action came back and said, well, these are still judicial acts, and it doesn't matter how poorly they do these things, immunity still applies. I'd like to send that to you, and which is the best way to send that to you, Cam?
You got my phone number? Or you can just send it to my email too.
Is the email on your website?
cam@piitp.com.
Yeah, okay.
Yeah, very easy.
I'll do that.
Okay. Yeah, that's interesting that the judge would acquiesce to an error like that.
Yeah, maybe it was how I worded it, but when I was drafting the thing, I made sure like I had very clear sections. I allege this person of doing this during this actions, had my facts, all that. But anyways, I digress, and we can get back to the video.
We'll take a look at it. Sounds interesting.
Has not been properly followed on me. I have not been given full disclosure of everything, including the accounting information, the bid bond, the performance bond, the payment bond, all accounting involved in this, as well as I have not been given the almost 1 hour video of the security footage from Save-A-Lot. Only 14 seconds is what I was informed from Mr. Jockins, and when I asked him for it, he denied me access to it. So I am not being given a fair shot. So I have removed him as my counsel.
Uh-oh.
I
Allegations.
can't see Mr. Lepper's in there. I don't know if the court wanted me to respond.
Sure, let me adjust the camera. Sorry for that.
Your Honor, I'm just going to back up and give a little bit of procedural history to the court. I know that the court always reviews the files. I'm just going to explain where I'm at. When I was initially assigned counsel on this case, I took the time and opportunity to review Mr. Lepper's and consult with Mr. Lepper's, not in person, but I did. With that information that was provided to me and speaking with other witnesses, family members, potentially, I decided it was appropriate to file a motion for a competency evaluation and inevitably criminal responsibility in this action. And the court could take notice to the
Okay, so right there, what he says is, I ended up filing the competency evaluation, right? And this is based not on him representing himself or being pro se, but based on the criminal actions that just happened. He just said it, right? So I don't know where we at. Right, let's go back 840. Yep, right here. Criminal responsibility in this action. So he's filing a competency based on the mental state of this dude not being criminally responsible for the action or claim that's being brought against him. So the lawyer's actually doing something like in favor of this guy, right? By saying, man, this dude might just not be competent enough to even really realize what he has done, right? There might be something here that's an issue. The lawyer's looking at it like that, right? But apparently this guy is not, and I don't even know the case. I don't know what he's charged with. I have no clue what's going on. So for me to say that this was a good action, I have no clue as far as what the lawyer was trying to do. But what I will say is that, like last night when we was talking about it, they was taking it as competency of the dude to represent himself or be pro se. And as we see now, that's not the case. It was that this lawyer was filing for competency of this guy to even be responsible for the criminal action that's being brought against him. And it might have been a good play. It might have been just a good play. You know what I'm saying? But we'll never know.
Responsibility in this action, and the court could take notice to Mr. Lepper's remarks, motion, etc. Judge, I provide everything, to Mr. Lepper's, as I do for all of my clients, and I do follow the Michigan Constitution, the United States Constitution, and every case I have is as important as anything that is going on. With that in mind, Judge, I got notice of this was supposed to be, I believe, on the 7th or 8th of April, and I had contacted the clerk indicating that I didn't think that it was appropriate at that time because we still do not have the evaluation that was returned from the MDHHS regarding the forensic evaluation. And maybe the court can understand the reason why I requested this evaluation, regardless if something was like a ChatGPT sovereign motion. If the court wishes.
Okay, a ChatGPT. So I'm not sure if he uses GPT much, but apparently there's one out there that's called ChatGPT. Might have to check that out. Maybe it's a little bootleg, a little cheaper, but maybe the same thing. Y'all let me know if y'all find out any information about that, because Jawkins knows about ChatGPT.
To remove me, I am fine with that. If somebody doesn't want me to represent them, that's fine. But at the same time, I meet all of my obligations and do everything that I am supposed to do with each client, even more so. So with that in mind, Judge, the only concern that I have is that we're still waiting on a forensic evaluation that Mr. Lepers had participated in approximately a calendar week back.
We got the motion. No order.
Yeah,
What did I do a calendar week back?
I don't show where, I see where, at least I can't put my hands on it now, but I remember you filing a motion, but I have not signed an order for a competency evaluation yet.
Well, with that in mind, Judge, I don't know what the court would like to do. If the court would like me to get, I thought that I had provided a competency order, SCAO form. If not, Your Honor, I'm fine with Mr. Lepers proceeding on his own.
Your Honor, I object.
Hold on. Yeah, so I show that there was a motion filed by Mr. Jawkins on March 23rd for motion for evaluation of defendant's competency to stand trial. And actually, I believe it was that same day we received the defendant's motion, Mr. Leffer's notice of self-representation and motion to withdraw. And then the next day we received an updated copy of that notice of self-representation and motion to withdraw. So I believe this is the first time we're here since these have been filed. And it's generally the court's practice to have a hearing before just granting a competency request. So that was one of the reasons we were here today. So we were actually set for a preliminary examination and these motions. So I believe it obviously is not appropriate to do the prelim today. And so that gets us to the motions. So I guess, Mr. Jawkins, I'm going to turn to you quickly. Your take on the situation. I know you said that you are okay.
This is an honorable judge, bro. This is an honorable judge, bro. This is a pretty fair judge. He's explaining everything. He's going step by step. He's giving homeboy his rights. He's recognizing that, yeah, there was a competency that's being thrown out here from this lawyer wanting to go a certain route. Homeboy's wanting to go a different route. The judge is listening. It's very honorable. But again, we got to understand that there's a process and procedure to this thing, man. If you follow the yellow brick road and go down that procedure somewhat and take control, like Joe has, like several, like Danny has, like several other has within this meeting right here and within Operation Wisedome. I mean, you got so many people that are going down the path and the process and then taking control of it, right? To where they get to the point to where they're bringing forth a lawsuit. But if you coming through and just spewing out all of the allegations or discrepancies that you have against the judge and the court because you're just now learning it, that's not the way to go. You got to follow a process, and the best way to do that is to bring forth documentation, right? Because that's why Wiggins right here just said that this judge, he just said, he goes, well, we were supposed to be here for the preliminary in a request for the competency, but now we got these motions on the table. So we're going to be addressing those instead of doing the prelim. You see what I'm saying? So he's literally cut out the whole prelim and the competency aspect because there's current motions on the record, which is very important. I mean, damn, dude's pretty honorable, is doing the right thing.
Okay, withdrawing, but do you believe that there has been such a breakdown as to require you to withdraw?
Your Honor, I cannot communicate with this individual. And my apologies. When I had communicated with the clerk's office, I was also, it was indicated that the exam was taken off the docket, and that might have been an email thread as well. So I hope the court doesn't think I'm being deliberately derelict or anything like that. But these are the reasons why I filed, this motion, Judge. But if Mr. Levis would like to proceed on his own, I'm not interested in. I'm the captain of everyone's ship, and I leave it at that. I
don't know why he's talking about he the captain of everyone's ship, but that's kind of weird. Like what makes you the captain? I guess it's because one is acquiescing to allow you to be the captain or to have that role. But
be his master.
Maybe it's if he's representing someone, he considers himself the captain of his ship while he's representing them.
That's crazy though to me, Sarah, and it's nice to hear your voice.
He probably just misspoke and forgot the word "not."
Maybe he wants to see pass.
There's a big difference between "I will now kill you" and "I will not kill you," and that big difference is one fucking letter.
It makes me just think of, man, why can't I just get this big real quick? Yeah. It makes me just think of this.
And so it's all just an excuse to talk about something else. We're not there to talk about why we're there in court. We're there to talk about competency. It's just a tool to, this guy's crazy because he's read some stuff and actually knows how the shit's supposed to work, but we're not doing any of that. So let's just go ahead and attack the competency. So see, notice how that took all of the steam out of the case. Right. They're not even talking about anything. And the craziest part to me about all this is they'll talk for days about that. Right. But they'll never grill the prosecution about doing things that they're supposed to do to even bring a court case in the first place.
Right.
I find it insane.
By alleging you're incompetent, they make you a ward of the court.
Right.
But right, like I said, it's just a tool to just talk about something else. So to just derail any argument that you brought in, hands down, this is dismissed like on 50 different points, but hey, he might not be competent. So it's just a tool to, let's set up some more hearings. Let's get him into a competency exam.
Okay, well then,
did we
let me ask you this?
We're waiting for the eval to come back.
Right.
It's just bullshit.
Well, let me ask you this: what would be if they're forcing that type shit upon you? What would be what would you go to seek as far as remedy is concerned? Then, what would be the route? What would be the strategy?
I would personally just state on the record in court, sir, I'm perfectly competent to present myself in this matter.
Who said that?
It's me, Sean.
Nice to hear from you, brother. As well as Sarah, like I said earlier. What kind of documents would you bring forth, and who would you bring them forth to?
I mean, that's a good question. I would just state on the record that I'm perfectly competent to present myself in court, and there's no need for a competency evaluation, and I'm not a ward of the court. I'm a free man in the union, boom. And then just move on. Like, why are we discussing my competency at all? Because you want to place me in your jurisdiction and under your authority, where you have none.
Right.
Because they don't have anything else.
Okay.
Right.
Okay. These are great. This is great conversation. Don't get it wrong. What I want to figure out from y'all is, what is the remedy? Where are you going after? If this court is saying we got an issue with you and your competency, and we don't believe that you're adequate enough to represent yourself, and they're forcing that on you now, where is your remedy? Where are you going to go from there if they're trying to play that role?
Aren't
practicing medicine from the bench?
One at a time.
Aren't they
Practic-
bringing the competency for the fact that he's not trying to take responsibility for the charge?
Yes, in this one, yes, but we're speaking of just Tony just brought it all the way out and said, "What if they're coming at you and saying that you're incompetent to defend yourself?" Period. What I'm
Wouldn't it
trying,
be an affidavit of standing?
okay, you could do that, but what I'm saying is, what is your remedy? Are you going to stay in that court to try and figure out if you're competent or not?
No.
Kick it out.
Willie said it. No. Why would you stay in that court if that court is forcing you to say, that is forcing the statement that you're incompetent to defend yourself? Why are you going to try and get remedies from them?
So bring a
You ain't
federal
gonna
question.
get it.
Why not take it up to a higher court to say, hey, look, they're making real big errors here, right? I would look at it as even if the judicial officer, such as a judge or the court, is acquiescing to the statements or the incompetency that is being brought forth from the state, right? I would look at that as a bias and prejudice to my right. Therefore, first off, a prosecutorial issue for sure, as far as misconduct is concerned. But then secondarily, that would be a judicial a violation, and I would find the canon where it was, because I mean that to me looks like a disqualification. You're prejudicing me. You're bringing in bias because I'm coming in with something that is different, or my beliefs are different from what you're normally seeing out here, but it still is applicable. But yet, because it's so applicable and so deep, you don't want to take the time to actually thoroughly go through these things properly, which is motions hearing, probable cause hearing, jurisdictional hearing, evidentiary hearing, whatever the hearings are based on, pretrial hearings, whatever the case is, right? You're not thoroughly adequately giving me due process.
Form of discrimination.
Exactly.
Well, yeah, you're right, but if you're not competent enough to rebut their claims that you're incompetent, then what they're saying is true. You're incompetent. So you need to be prepared to go in there. One of the things that they're going to do is try to claim that you're incompetent. And you prove that by one, your standing, how, what you're going to say at court at that time, but also your filings. It's really your filings. It doesn't necessarily matter what you say. I say that with, take that with a grain of salt. It does matter what you say at court, but it's what's going to stand stronger are your filings, is your record. So that when you take your records to a higher court, you have it, Your Honor, here, this higher court, here's the record. I have a notice. So with Elijah, I don't know if you guys remember, he received a court appointed attorney for his traffic matter. He filed a notice of, I forget how he worded it, but he filed basically a notice of rebuttal to accepting the court appointed attorney, and then a rejection of that, and then litigating the matter himself. He is not refusing. He does not waive his right to assistance of counsel, but he is waiving his right to court-appointed attorney, and he's going to litigate the matter himself. So it's really within your filings. If they're going to bring up the competency matter, you object to that, but you have to back that up so that they can't keep claiming that. And the way that you counter that is through your filings. And if they're going to steamroll you, then okay, we're just going to move through this court and I'm going to appeal it and we're going to deal with it. We're going to set the record straight. You make your filings so that when you take it to appellate court, you can improve the court's error that they're claiming you're incompetent and why it needs to be dealt with at a higher court of record. Something along those lines. My point, though, being is that you got to be prepared to rebut their tactics to pierce your competency.
Facts. And Aaron asks in the chat, hold on. Aaron asks in the chat, what is the remedy? How do you take it to a higher court? Well, okay, let's look at it in Marcus's case. Marcus had a whole bunch of lower bullshit going on, right, in the court, where they were just not honoring, they were just like steamrolling him, literally, not going by the rules. And the courts are just like, yeah, whatever, we're moving on. If you don't like it, we got this date, and we set the date, blah, 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 blah. Well, guess what Marcus does? He goes directly to the District Court of Appeals and files a mandamus. literally going right to the District Court of Appeals right then and there and files a mandamus, mandating that, okay, the court do what they're supposed to do, clearly bringing forth the errors. He's got the record to show, right, that they're making the errors, they're not honoring. So bringing forth the timeline and then saying, hey, look, I need you to mandate through a mandamus that they do what they're supposed to do. They got a duty to do it, and they're ignoring that duty and my process. So right in the middle of your process, by going through the court system, yes, you can appeal. You can appeal anything, bro. Any decision that's being made, you can appeal it right then and there. So just you got to take it to a higher court. That's all it really is, Aaron.
Even before there's an outcome, you can appeal.
Before there's an outcome.
Danger. Absolutely.
Yep.
Hey, what about the rebuttal of presumption as part of the solution, as part of your remedy? Isn't it an automatic? They're presuming you need to have a competency hearing. Isn't that a rebuttable presumption? It's like I rebut the presumption that the court feels I need to have competency. I'm competent to stand my own things. Under what presumption do you try to move forward?
That's actually interesting. That's actually interesting that you say that, because in this court thing that we're watching, that he actually comes through and does give the definition of the presumption and everything like that. So I kind of want to keep going through this and then get into that presumption. Actually, it's interesting. Let me see if I can get.
I don't have a good feeling about that when someone files a motion to withdraw and if they find out there. However, I still think it's appropriate for a competency evaluation. That's the reason why I had filed that, Judge.
So the lawyer here is not stating that he feels like dude needs a competency test based on his eligibility to present himself in the court through self-representation. But again, he's mentioning that he's stating this based on the fact that homeboy may have not been competent. There's an issue here with apparently the crime or the charges that are being held against him. So even though he's withdrawing, he's still asking the court to do a competency based on the allegations that are being brought forth, which is a hint to the judge in the sense of, hey, I really don't think homeboy is being fairly charged in this crime here, which is kind of crazy that he's still trying to defend him in some form or fashion. I don't know. You can look at it in different ways, but that's how I'm seeing it.
All right.
Yeah, that's not how I see it.
Mr. It's Leffers or Leafers? I know you said, and I apologize.
Well, Tony, based on your experience, I could see why you wouldn't see it that way. But based on what's been said, I agree with Cam, because he said if he asked it, or it's about figuring out if he's competent enough to stand trial.
Right,
So
but
I
that's
don't
not
know, are they thinking of claiming insanity or what? Because that's
Right.
a thing too.
Right. Exactly. And one of the things in this one, Tony, is that even later, I really don't want to watch all this, but I guess we can if we want. Even later in this, dude's on the record kind of like admitting to some of the allegations that are being brought against him. Which it's kind of like, what is really going on here, bro? Like, watch. Okay, we'll keep going. I'll keep going.
Not entering into any.
I understand.
It is living in Quincy, Illinois. We were there for the Oktoberfest. They do a German exchange in Quincy, Illinois, where I was. Ran into family lineage and actually tracked down all of the Leaper's claim. And he gave me old records from the 16th century. It's left.
See, so homeboy's now bringing in his lineage, right, from the 16th century, and the claims that his family has made type vibes. Like, this ain't the place. This ain't the time and place for that, bro. I'm just being honest. This ain't the time and place.
Leffers.
Now, it depends on which one to go with. There were over 7 Leffers families. They were all together.
Okay.
Second. And then I think it was like 80, 100 years later. It jumped to like 13 or 14.
So you're talking about 80, 100 years later. That ain't even a real thing, bro. Like, what are you talking about?
You sound like he's incompetent. He don't have no
So I want to make sure
education.
Yeah, he not doing good in this in any of this, and that's why I'm you gotta know the process, y'all.
I'm following your request, and I understand that you have some arguments as to one, whether or not the court has lawful jurisdiction, lawful authority, and also a question of whether or not you have been provided with appropriate due process. couple that with is your request to represent yourself. Am I correct on that?
Yes.
All right. And are you requesting to represent yourself?
Yes.
See, me, I think that's kind of a trick question of authority. Some people don't think of
Very
it like
trick
that.
question.
Yeah. Some people, yeah, last night when I said that too, they was like, no, that's not what it is. It's just straight up. Listen, I think that's an authoritative question. Are you requesting from me to self-represent? I'm not
That gives
requesting, Your
jurisdiction.
Honor, nothing. I'm telling
That's
you.
exactly it.
You notice how when you make a statement, they'll ask you a question. They'll kind of like repeat it, and they'll ask you for a yes or no, affirmative, or like to affirm or deny it. That's a trick question in itself. If you don't repeat exactly what you just stated, then it's basically relinquishing that authority that they're trying to demonstrate for the record. Does that make sense?
Yes, it makes sense, Rich. Good statement, bro. I love it. Bro, where you been at, nigga? Damn. You had some great comments, bro. I love it so much.
You do understand that you have the right to have an attorney that either you could hire or that the court would appoint, as opposed to you representing yourself. Do you understand that?
Yes. My creator has placed a lot of friends.
You know, and I'm not trying to be rude here, but like I think dude is showing up in the court with like holes in his shirt or just a lot of like dirt on the shirt. Like he's not coming through, but
Could be homeless.
he could be. But I mean,
Wait,
he's
are
got
you
a lot of
saying you're
paper.
watching this in 4K?
He could be.
It looks like a jumper out of jail.
Yeah, he could be. I'm not gonna judge like that, but I'm just gonna
So
say
yeah,
like
you're correct.
come, present yourself well.
Yeah.
Around me.
Looks are everything.
Wonderful information that I never knew. And I'm grateful to know this now. I'm sorry for being caught in dishonor.
Okay, you hear that, Tony? I'm sorry for being caught in dishonor. Watch this. In the past, look what he's about to say.
In the past. It will not, Yahuwah willing, happen again. I understand my place, and I have always tried to respect the way that things are. That's why I need to finish this as well, sir, please.
Go ahead.
In written discovery not being met, there are no medical records, let alone a psych evaluation proving any type of trauma. No harm has been done, no pain has been inflicted, and no property was damaged.
So you can see the homeboy ask, hey, I need to get this on the record. I need to state this. And the judge is like, all right, man, go ahead. He's like, all right, go ahead. Honorable judge, bro. I'll tell you that much. But the judge is listening, and then he's like, what is dude finna say? And how is dude finna present himself and move this court to work in, yes, Joe Ellis, that fist has 6 fingers for sure. Someone figured it out in the comments on that video last night. It's some kind of power movement of some sort. It was in the comments. I don't know. They figured it out. I should take a screenshot and see if I can find it too, but yeah.
Are you able to pump the gain on that a little bit, by chance?
What's up, brother?
Are you able to pump the gain up on that video by chance? It's
Yeah,
a
let me
little bit difficult to hear.
Yeah, let me see what's
I don't
going
know
on.
if anyone else is having that issue, but I just want to bring that up.
No, you good. Let me see if I can.
No.
Alcohol testing. I don't drink anymore. That was an issue. Not anymore. But in the same token, I can no longer contract with it, knowing that everything's.
Anyway, I'm on the phone, so when I get to the, like I said, when I get to the office, I won't have that issue.
I'm pumping it up.
Since the motorcycle wreck, things have been very uneasy, trying to sleep at night. Period. Definition of presumption. An idea that is taken to be true.
Now, I know you hear this. I don't know why it's stomping on me.
No, I can hear it. It's just difficult. So.
Yeah, no, this whole thing is tripping out on me now.
My bad, y'all. I didn't mean to.
Basis of probability.
No, it's better now, though.
Presumption of which must be agreed by the parties to be true. Then, and equally, if one party challenges the presumption to be true on the basis of probability, then all that is required. Definition of presumption. An idea that is taken to be true on the basis of probability as a presumption on which must be agreed by the parties to be true. Then, and equally, if one.
Damn, that's really crazy, bro. But Descript just like is adding its own AI like voice to boost the volume of this audio. I've never noticed that until now, and That's pretty weird, bro. I'm literally hearing it. I got all these huge speakers, like old school speakers. It's weird. Dang.
That's interesting.
It is interesting. It's so weird I can hear it.
One party challenges the presumption to be true on the basis of probability, then all that is required to remove the presumption is a formal challenge. That presumption, the presumption, then has no standing or merit in fact. Probability. The extent to which something is probable.
See, so like right now, what is he doing? All he's doing is literally bringing in. He's bringing in definitions, bro. So, this is not the time and place, y'all.
Color of the law. Therefore, if presumptions presented by the private bar guild are not rebutted, they become a fact. Therefore, said to stand true. There are 12 key custody.
Going, bro.
Court of guardians is a matter for the public record. In fact,
What's wrong with the audio?
semicolon leafers the undersigned formally challenge the presumption of public record, as it is by definition a presumption, and by definition has no standing or merit in presentable or marital fact. Section 2I. The presumption of public service is that all the members of the private bar guild who have all sworn a solemn, secret, absolute oath to their guild, then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradicts their private superior oaths to their own guild. Unless openly refused and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. I am back in place. I do not need a trustee over my estate. Will govern. That's my creator wants me to. I, Philip Andrew semicolon Leathers, the undersigned formally challenge the presumption of public service, as it is by definition a presumption, and by definition has no standing or merit in presentable or marital fact. Section 3I. The presumption of public oath is that all members of the private bar guild acting in the capacity of public officials who have sworn a solemn public oath remain bound by that oath, and therefore bound to serve honestly, impartiality, and fairly as dictated by the oath. Unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must recuse themselves as having a conflict of interest and cannot possibly stand.
Okay, so the judge, if you can see here, allows dude to talk from, where are we at? 15:58. Okay, so about 16 minutes, all the way up to 26 minutes, damn near. So he lets him talk for 10 minutes straight. And dude is literally said nothing to move the court whatsoever. So this is what ends up happening.
I don't think it's relevant. This is just rambling and rambling and rambling. Chat GBT, sovereign citizen stuff.
All right, Mr. Leffers, I need you to stop for a second. So this is what I'm going to do. Mr. Jockins, I'm going to allow you out of the case.
So you see what happens here? Y'all got to really realize this. He's bringing all this stuff into the record at a wrong place and time and just reading information that is not relevant to moving the court to do exactly what he needs to do at that particular time. I mean, you need to be, I'm going to come in precise. All right, I need discovery. I need it by this point. I've also filed a bill of particulars, which the state has failed to answer. It's already been 16 days. I've just removed Homeboy. Thank you for removing him. Jockins, he can go. The evaluation in and of itself, I guess the Jockins is wanting to get it based on my capability or the issues that may be with the state as far as the claim that's being made against me, as far as my competency is concerned. I think I've done that. I think he already did that, right? Say I've already did that. You can wait on the analysis in and of itself, but still I don't want Homeboy on my case. And I'm ready to move forward because the state has failed to answer in relation to the filings that I just filed. You know, so you're coming in strong, but you're not coming in with talking about leafers of the 16th century and how that's your lineage. And then, you know, you bringing in presumption of law definitions. Like, bro, bring all that through in the judicial notice that you file with the court. It's almost like almost like Joe said, like, what was you doing, Joe? I'm bringing it through my filings. It's great what I say to back up what I'm bringing forth, but answers need to be brought forth through orders, factual findings, conclusions of law from the judge. That's their duty. They owe you that, right? So why are we not utilizing the rules of criminal procedure? Like, it is very strict, bro. There's a lot of duties that are to be given to you. Like, there's things that they owe you. You just got to pull them out and invoke that they give that duty to you. in the particular ways that they're supposed to do it. It's like that's where we're finding out now, like the lawyers that are in place, they kind of got taught not to, I guess. I don't know. I haven't gone through what it is to become a lawyer. I don't know what they teach, but I'm sure I'll probably pass it because shit, we're surpassing that as far as knowledge is concerned. Um, like, yeah, bro, this is getting really weird out here now that we're just continuously learning, but I'll let this go.
So I'll sign an order in that regard. So you're free to go.
Okay, thank you, Judge.
All right, thank you. Now, sir, that I know you have a lot to get out there. One of the things that I have to be concerned with is if you are to represent yourself, that you have the understanding of the court rules and procedure. Now, I know, and admittedly, it's been a while since I've seen this type of material out there, but I have seen it, and I'm familiar with the position that you have. And I understand that you are essentially challenging the authority that one, I have as the judge, two, that this court in totality has, and three, anything that any charges that the prosecutor might have. I can tell you that based on what I'm hearing today, I'm not going to allow you to represent yourself. I don't think, while I understand that those are your beliefs and your feelings, I don't think that represents a true grasp of the reality of how this republic works, how the state works, and how the court works. And so for you...
Maybe he's saying that because homie said he had a C-Pass, but I want to see the C-Pass. Y'all still ain't found the C-Pass? Nobody found the C-Pass yet? No? Okay.
You're only going to find that
C-Pass. I don't even know
man.
what a C-Pass is. I've heard of it.
I want the C-Pass, bro.
I don't
present
even know
yourself,
what it is.
I think is going to potentially do more harm than good for you. So what I'm going to do, I've as you've heard, I've allowed Mr. Jockins out of the case. But what I'm going to do is I'm going to make another referral to another attorney for you. All right. It's not that I don't think that you're smart enough to handle the case. That's not it at all. I have there's some procedural issues here that I don't think you quite grasp how it works. And that is, I'm going to be honest, will probably go to your detriment. And that's and you've got some pretty serious charges here. One of them is a 4-year felony. Means, you could have up to 4 years in prison. So I want to make sure that you have the appropriate legal representation. And for that,
look at the prosecution. The prosecution hasn't spoken one word the whole time.
That I'm going to deny the request for you to be able to represent yourself. So we'll make another referral to the public defender's office. It might take a little bit of time because for whatever reason, this case went to a conflict attorney, which tells me that the public defender's office has some sort of conflict. What that conflict is, I don't know. But that's how Mr. Jockins came in. He's a conflict attorney that they work with, so they'll have to reach out and find another attorney for you. Okay. Your Honor. Yes.
He still keeps fighting.
The court to dismiss all charges at the same time. Next, please. Case number 26-891-SN-1, which came to the Richmond because of these false charges that have been placed upon me.
So,
and had the officers actually done their due diligence and looked at the video footage, which is almost an hour long.
Okay. Now this is what's going on. Homeboy's got an allegation that the cops should have looked at the footage that is an hour long, proving I never ran is what he says, right? Okay. Why are you mentioning this here, bro? I'm going to ask y'all, what would be the proper way to bring forth what he is stating right now orally?
A motion.
Affidavit.
Discovery.
Say that again. What? I missed it.
Okay. So let's do this. So we're going to come, where are we at? 13, 15, 16, somewhere around there? Okay, so we'll come back to 33.
So, and had the officers actually done their due diligence and looked at the video footage, which is almost an hour long, proving I never ran anyone over, never threatened to. So no.
Okay, so no harm was done. If you trying to bring that forth, what would be the proper way to bring forth that statement into the court?
An affidavit and a motion in support of.
Yeah. File it before you ever go into court.
Yeah,
An affidavit and a motion in support of it.
I would ask for
notice and demand.
discovery and explanation of elements of the charging instrument.
Motion to dismiss for failure to state a claim and then give the supporting video as evidence.
That's right. I agree with that.
Discovery hearing.
Discovery hearing. Getting closer.
Evidentiary hearing.
Evidentiary hearing. Yep.
Yeah, that's what I meant.
You want to bring forth a notice of evidentiary hearing for sure. Reason being is because you need to get in there and question everybody. What evidence is coming in? What evidence ain't? Who's telling lies? Who isn't? Where does it match up? Where's fruit of the poisonous tree?
So I'm guessing this is like a few different sessions we've had in this video where they got spliced together. So like, where are we at in the trial? Is this supposed to be a
No, this
probable
is
cause hearing? Or?
No, this is just one. This is just one hearing, bro.
Oh, this was all one hearing?
This is all one
I thought it
hearing.
was like
Yeah,
two or
dude just
three put
running his
together.
mouth. That's what I'm saying. Dude just running his mouth. This hearing should have been so short, bro.
This is
Yeah.
first appearance? Is this first appearance?
No. This is an appearance though for him to get rid of the lawyer. He never even came into the courtroom or came up to the table whatsoever. He stood outside.
Should have been
Look at
short
it,
and
y'all.
sweet.
Yeah.
I'm getting rid of representation.
So
we're setting another date.
But this is a 38-minute damn ordeal when it should have been, literally
10.
12 minutes. Yeah, 10 minutes.
Yeah.
Yeah.
Disposing.
So, anyways, when he's coming through and on the record right now saying, I want you to move to dismiss right now orally on the record because the officers saw this and they knew that I never drove over anybody. And so no harm was done. Bro, that's getting proven in an evidentiary hearing, not by you orally stating it in a hearing to dismiss current representation. What's up, Aaron? How you doing, bro?
How are you, Cam? Nice to meet you.
Doing good, bro. Nice to meet you as well. See the work that you're doing, and it's greatly appreciated. Please continue to do such, bro. You're making some waves. You may not get the attention that you want right now, but keep going. Okay. Go ahead.
I have a question. Okay, so in the event, let's say, okay, so what we're supposed to do in this case is do an evidentiary hearing. Now, say we did that, how would that have gone?
Okay, so like on the YouTube channel, we have Hayden's hearing, and everybody has access to Hayden's Discord. If you just type in Hayden, you can go to Hayden's Discord and start from the beginning and show all the way to the end. You got to bring it forth, but what mostly goes is you're getting to interview or cross-examination or depose anyone that's involved in the crime. So if you have reviewed, like, let's say, like Hayden was reviewing his case, and he was like, well, man, there's a lot of constitutional violations throughout the interaction that had happened. But what was the first one? And the first one, through finding out a lot of them, okay, because that's what you want to do. If like one's getting denied as okay, or that they're just going to let it pass, shit, what about all these other constitutional violations? So in the timeline, essentially, in the timeline of what's happening, of events, there's several constitutional violations. Which one is going to stick to then eliminate everything else as far as a motion to suppress all evidence, right? Where is that point on the timeline that we're finding to dismiss? So in a sense, like how Hayden did it, how I'm thinking could be applicable in some people's situations, not all, is that like you coming through with a motion to suppress based on the constitutional violation and where it's at on that timeline, right? I mean, that's how you think of it, Joe, right? That's what you thinking, Danny? I mean, like, what y'all thinking?
And thank you, Cam.
Yeah, I'm just wondering how everybody else thinks, because in Hayden's situation, he brought forth a motion to dismiss, I believe, as unconstitutionally applied. And in his prayer for relief, he asked a little bit more of suppression question, and then brought in some suppression elements, if there was to be any, through fruit of the poisonous tree. And then the judge at that hearing, going over said motion to suppress or notice in demand to dismiss, said that she went through it and said, I'm going to take this as a motion to suppress and hold it under advisement. So she just held it under advisement. She didn't grant or deny. She said, I'm holding it under advisement. We're going to schedule this evidentiary hearing. We're going to go through this situation together. For real. That's what she did. We're going to go through this situation together. And when they went through that situation together, Hayden came through with such, questions already developed, ready to go. But then when he gets an answer, going into follow-up questions that are hidden secondary on the subconscious, whether it gets objected to by the state or not. You know what I'm saying? At least you're able to try and go down certain routes, because the state may not even be paying attention and let a question or two slide through because they thinking of something else. I know in my depositions that happened all the time. Like, oh, we can object to it, but he still got to answer it anyways. You right. It's a little different in federal depositions, but go ahead. Yeah, you're muted though.
So say you get them to dismiss whatever the case. How do you go for remedy from there?
Oh, that's a Kane question. How do you go for remedy, Kane?
You file that 1983.
1983.
But you can file for lots of different claims, bro. You can file for kidnapping. You can file for anything. You file a Monell claim against.
In that moment too, that as soon as you dismiss it, you can go into.
Hey, you can file it before they even dismiss it. In my WSP case, my Washington State Patrol, there's a whole bunch of channels online that are like saying I was crazy and I was mental, or saying like, bro, I was hype, bro. They turned me to hype mode. You know what I'm saying? And they like, he looks crazy. I'm like, oh, thank you, God, because I know this where this is going. You know, I'm hype. I'm hype as fuck, bro. So when they see that hypeness, they just like they don't understand because I already see. I can see further down the timeline than most people can see. Most people are day-to-day seers. I'm like, this is turning and will turn into a lawsuit. So yeah, man, it's kind of weird, but yeah, I filed a lawsuit before they even dropped the case. And like I could go through the emails through them. Like, let me see. I could go through the emails with them. You know, we were in communication where I'm telling them, hey, I've already filed a lawsuit. This is the case number. I need all the evidence, you know, for that lawsuit. And they're just like, yep, all right, we got you, buddy. Straight, send them all over to me in the email. No issues. All the body cam, everything. And then as soon as I show up, they drop the case. Like it wasn't even. It was. I went to the prosecutor's office. I said, "Hey, man, have you been getting my correspondence in relation to this situation?" He's like, "Yeah." I'm like, "All right, cool. Well, what do you want to do with it?" I'm like, "Where you want to go?" He's like, "We're just going to dismiss it." I was like, "Okay, cool."
You get paid off for that if once they dismiss it.
Yeah.
No, through the lawsuit when you're filing a lawsuit, that's where you get your remedy. So, like, we have several people that have
What
civil
about Bill?
lawsuits right now, and it's all in the Discord. And I've been slacking on updating mine. I actually need to go through mine and show y'all what's going on. But the docket's available too. Y'all can check out the docket. You know, everybody knows my case numbers. But yeah, like, are you not in the Discord or what? Oh yeah,
I just got. I'm just in. You know, I just came across your. I literally saw your Zoom call. I was like, boom, let me hop in. I was like,
yeah,
oh,
bro. Yeah, bro. So it's cool that you vibing with us. Yeah, we're kind of going through this case where this dude is just doing really horribly. I don't know if you've been like with us through that, but like this guy is going through the court really horribly, and we're just trying to figure out like where my people at, like where we know as far as what we do in the process. Actually, I want to move into Bob's though. Bob, are you still available?
I am, sir.
All right,
Give me
so
that remedy.
what? Just trying to get remedy too. Aaron's talking about remedy. Yeah, let's get into Bob's situation. So
Jack tried to do bill for damages in his brief.
what? Say that one more time.
Jack tried to bill for damages in his brief.
Who did?
Me.
Jack.
And it wasn't in my brief. It was a separate
Oh,
motion.
Okay, so let's see. We're going over here too. Yeah, if you're not on the Discord, let me see. Where do I want to put you at initially? You got to come to this one. Copy. I still want to see the chat though. Where's the chat? Move this over. Chat. There it goes right there. Okay, in the chat. Here's the Discord, Joe. What y'all posting in here? Joe's got some juicy stuff. Okay, watch out, Joe. Yeah, y'all check out those. Joe in the chat right now. He's just doing a notice of non-consent to representation and a notice of private counsel, both through Overleaf. Thank you for that, Joe. Good examples, y'all. Always make sure, man, that you checking out what other people are doing, especially Joe. Joe's been with us for a long time, so if you're just hopping in, pay attention, man. These are examples that you can utilize in not only in your research, but also if situations arise to where you can edit and develop and or revise for your situation and your state, according again to the rules of criminal procedure. Again, maxims, canons, doctrines, right? Because what we want to do is when we're coming through, we want to be able to support every statement that we make with some kind of case opinion, case law. I hate saying case law. Most people are case opinion.
I hate it. You
Yep.
know my feeling about it.
So we'll stay. We'll stay with what we got. You know, people on the cool, on the depths of it. So let's get over to Get Bob's case. If you're in the Discord and you in this chat right now, what I also want y'all to do is, can you just like go congratulate Bob in the Discord? Right, he
I
won
want
this
to
battle.
tell him congratulations right now.
So why don't we do that as well? Everybody, y'all.
Congratulations, Bob.
Way to go,
Congratulations,
Bob.
Bob.
Congratulations,
job,
Bob.
Congratulations, Bob.
Congratulations.
That was amazing, bro.
Bro went all
Great
Nah.
job, bud.
Thanks
went
to
all
you, we all know that a river's not a highway.
straight up. That was amazing. Perfect. Let's Joe. I mean Bob. Do we show where you started off at? Where's it at? What street is it off of? Do you remember? It's not this one. Nope, it's not this one either. Salem Justice Court. What road is it off of?
It's off of River Haven or
I don't think
Homestead,
I don't think it was Homestead either.
Farragate.
It's not that one. It's not that one either. No, it's not this one.
Lockmere.
What street is it off of? It might be this one. It might be this one. How do I get to? Yeah, it's this one. It's this one. It's this one. It's this one, Bob. Okay, so this isn't really a courthouse. I just want to show y'all. Look what it is, y'all. Okay, can y'all see this? Oh no.
The court, the Justice Court.
Yeah.
The strip mall.
Yeah, can y'all see this, everybody?
Wow.
Yeah.
Okay.
Oh yeah, see it good.
Y'all see it?
Lancaster.
Can I zoom in?
That's like the
Right next-
DMV, man. That's straight up administrative court, man.
Administrative court. Joe just said it perfectly. Okay, this is Jesus, our Jubilee here. Okay, they got the church right next door, bro.
Let me tell you how I walked in.
Robbing people by the church.
Yeah.
Wow.
Let me tell you how secure it is too. So I'm in my white shirt and tie with briefcase, and I've got my state badge on, and I cordially smiled to the security guy. Are you hearing me?
Yes, we're hearing you,
Yeah, I
brother.
can hear you. Hey, Bob, did you have to take a number when you went in there? Wait in line?
No,
Anyway, go ahead.
I'm the only one there basically, and I've got this briefcase that was my father's, so it's like 50 years old. It just looks like I'm this high-powered lawyer, and he doesn't even bother to look in my briefcase, and he just waves me through the security aisle or he waves me around it, and I decide to go through it to set off the bells and whistles just because I'm an asshole, and they go off, and I could have had the grenade and guns in my briefcase because he never looked in it. So I go into the courtroom, and I get found guilty in the justice court because the judge decides that a highway the river is a highway. So I appeal that case. This is November, or this is from the 4th of July ticket. And now I go to court Wednesday, April 15th. A nice day to have looming over you for court, April 15th.
Yeah.
So I went in and paid $391 to the Supreme Court for the mandamus I filed on Monday to move the court because they hadn't responded to any of the paperwork. I filed a motion to notice for demand and dismissal for
Now,
lack of
Bob, when you went in to file the mandamus, how did that process go?
it was there was two separate pieces. There was the social piece, and then there was the legal process.
Mm-hmm.
The social one was real interesting.
Mm-hmm.
The guard bailiff at the gate, again, I was real casual this time. I had my red hunting shirt and a white t-shirt underneath that nobody could see. It said Bob. Actually, it said 90% Bob and 10% Robert. And so I go in and I file the paperwork, and they were kind of goofy on what to do with it. And I said, I'm pretty sure you can attach it to my current case, and then I only have to pay $90. And then they gave me this paperwork that said, well, if it's a new case, then it'll be $390. But if you qualify for a waiver because of hardship, then, then poor Bobby, we can pat you on the head and send you on the way. And while they were in the back trying to figure that out, I took my t-shirt off and took it out and gave it to the nice guard in front named Bob. and he wouldn't take it because he said he'd get fired. And I said, hell, you can't influence my case. You're the stinking door monitor. And so he gave it back to me because he was, jeopardy. And I, respected that. And I took it back. And while they were still in the back room, I just decided, shit, I'm going to throw it on the floor.
Right.
I'm going to walk out when we're all done, and he's going to have a t-shirt because he saw my t-shirt when I showed Bob, 90% Bob and 10% Robert. He said, yeah, my kids would love that. And,
yeah,
I love kids and family. And so anyhow, I filed the mandamus and walked out. He said, hey, you forgot your shirt. And I said, what shirt? And so that was Monday. And then Wednesday, I went back in and paid for it. And this is another thing. I was telling him my story about the briefcase, and that was my father's, and I'm a junior, and how I got inherited that. And my dad told me change. I'd post that in the first of this chat.
Yep.
Change.
Yep.
Expect it, accept it, adapt to it.
Right.
My father told me that on his deathbed when I was 15, after I was paralyzed in a football game, after I was a quarterback, driving my team down with doing power plays in the fourth quarter. And we scored to tie the game. I did a bootleg. I was dead meat. The guy had me cold. The defender had me cold. I had the ball on my hip. All I could do is slow my stride down, turn my helmet back and look at the scrimmage pile. The defender took my fake. He turned his helmet to look at the scrimmage pile. I jetted to the corner of the end zone, the go-ahead point. The next play was a kickoff. I'm in on the tackle. I see Haley's Comet. A lot of stars. Hell, I'd been on tackles where, stars and pain, and no pain this time, but piles unloading, and I start to get up and I can't move. I'm paralyzed. They take me off the field in an ambulance. I spend the night in the same hospital that my dad's in. I find his room that night, and he tells me, change, expect it, accept it, adapt to it. Those words did me well. I'm 79 years old.
Let's go.
And these words and my ability to stand on the strength and courage that he instilled on me.
Yeah.
And in the court, Judge Wu was professional, and he started with basically not the mandamus was ruled moot before I even paid for it, which was kind of foolish of me. I didn't even know that. I just gave him my card and had told Bob the story that I just told you guys about change. And so Judge Wu began, and he started with this motion that I filed February 12th. That was the motion to demand for dismissal for lack of subject matter jurisdiction. And he started with, okay, well, let's look at the wording of the ORS 166.630, which is what I was cited for. And he asked the deputy, do you have any, anything to say in support of your charge? And he did not.
Good.
Then he just went through the words, and I hit him with the old expressio unis exclusio alterius.
Okay, watch out. Lee said it too. Let's go. Let's go.
The inclusion of one, the ocean, excludes all else. The
Let's go. Ooh, I love you, Bob. You're so good, bro. That was
What
so
does it
perfect.
mean
Bro.
again? Can you say what it means again?
Sure. The inclusion of one, the ocean, excludes all else, the Willamette River.
Yeah.
You know what's so crazy about this? This was just like universally aligned right now, because homie just said, he was like, "Oh, I turned in maybe like February some." So I'm trying to look back and figure out which one he filed, and I find it. I think I find it in the overleaf through his channel, and then I scroll down, and we're over where he's talking about 166, and homie didn't have nothing really to say, right? But then he already was mentioning expressio unias ex exclusio autoris before I even saw it. And while he's saying it, I'm looking down and I see it, so I highlight it, and then he just literally brings forth everything in relation to the English as well, which is, I'll read this sentence, which is included in his notice and demand, which he almost explicitly stated verbatim. That's how well he knows what the hell's going on with his case. Y'all see that? Like, Bob knows exactly, because that's why he just mentioned it. And he almost verbatim said this sentence, which is brought forth in the most highest legalese possible. Now watch. The canon of statutory construction, okay? Listen, the canon of statutory construction, meaning that there is a canon of statutory construction. You should look that up to figure out what is statutory construction. It states, or expressio unias et exclusio autorius, okay? So that's a maxim and a doctrine all in one. The expression of one thing is the exclusion of another, which dictates that if the legislature had intended to include all navigable rivers, it would have said so. Or would have not or it would not have specifically listed the ocean shore. So Bob just literally said verbatim. Like you can't have one with okay, go on, Bob.
That was pretty much it. The judge said, "Well, let's look at the ORS, the statute," and he began reading the statute, and he said ocean shore, and I jumped in, interrupted him and with the Latin, and he said, you can't interrupt me, but he heard it and he can't unhear, the bell has been rung.
Yep.
And he went on, and he's a good judge. He said, yeah, basically the words aren't in there. And so he just dismissed the case. It took half an hour for me to have me quit interrupting him and me.
Well, wait, what was going on after that? Y'all just argued literally just the statute itself, and that's it? And then he was just like, come on, give me more. It's so juicy, Bob. I want to know.
Yeah, I wanted to get into all of my arguments.
I remember this from your Most Sacred of Liberties.
I had 9 months to stress over this and
Yep.
research, and you guys just busted your butt, supporting me on this, and I couldn't believe all the knowledge I've gained with this. I should go out there and
It's crazy though to really think about, right? Because in the process of it, you're gaining for yourself, you're benefiting for yourself, which is empowerment, right? In several different aspects of law, not just for yourself, but then through everybody else in Wisedome, in their existence and experience. But then also you're looking at it like, I've really suffered some harm here.
Oh
Right?
God!
You see what I'm saying?
But it cost me my caretaker, who was like a wife. I didn't have to, do husbandly things.
For real though. Like,
I don't have to pay alimony. Let's put it that way.
So you're saying that it was just too easy as far as everything is concerned. It was too quick and so easy.
Yeah, I mean I guess I had we had my shit together so well that I didn't have to do anything other than just. It was, I guess it was this. Is so simple that I read the law 6 years ago. The first sheriff came up. I quoted the law to him. I said, "The river is not a road," and he goes, "Yeah, you're right." In his report, he wrote, "No PC." That was the end of his report. No PC at this time. That was 6 years ago. And they've been coming here since then. And I've been telling them the river is not a highway.
Go
so how many shots have you fired across the river since it's been ruled? I've been popping them off, man.
Right, not to incriminate myself.
Hey, we're about to go have a shooting party over at Bob's place now, across the river, bro. Like, as loud as hell, bro. Like
I've been
put it into a
July,
statute. I can do it. You know what I'm saying? Like,
I've been looking on Amazon for floating bells. I can, shoot at that go ping, ting,
Yeah, you should literally, if you can, just get away with it. Have someone now seriously go put targets across the river, bro. Like literally things that are just kind of sitting on the bank, that you can.
Well, I actually took one down because I was so paranoid after. Yeah, it was like nope, paper 11 by 14, whatever piece of steel.
Okay, but what does this mean now for you?
Well, I don't know. I emptied a couple magazines this morning.
No, I'm talking about court-wise.
Well, I'd like to get some remedy because they should have known I mean, I read the law and I understood it 6 years ago, and the first deputy came out and I explained to him, and he went away when he wrote in his report, no PC.
Right. There was no issue there, but now they come across this time and they want to cause an issue.
Okay, here's another thing.
Hey, listen to me. That's a real good distinction and clarity you can make there. Okay, I want you to remember that. The distinction is that they came out 6 years ago and they knew it wasn't an issue because the statute didn't apply. Now, just because someone's complaining, y'all want to come out here and cause an issue again to where I have to go through all of this bullshit through the courts to try and learn for myself because I ain't finna let nobody else represent me. I'm 79 years old. I ain't about to be fooled. And I know the law. I looked at it and read it. It clearly states ocean shore. So I don't even see how they applied it. Nor do I understand how just a kid could sit here and continuously push that on and then try to reference some kind of civil case. I got to come all the way through over to hear it from you, Judge Boo, to finally get that decision. Went through all this stress to where I couldn't even exercise my rights. My liberties were taken away because of the possible eligibility that at any point in time, these people could just come through with an anonymous 911 call that I can't even cross-examine. You see what I'm saying? All of these violations are occurring, bro. And you occurred all of this harm over a certain amount of time. That's the point I try to make to everybody is that they just been getting away with it for so long and they just feel like it's okay. Like, bro, you don't get to just violate my rights and ruin a certain portion or timeline of my life by stressing me and making me come. And if not, I'm going to be under the threat of arrest. That's a mobster mentality. Like, how do you do that? Why can't I live free and self-govern?
But it's worse than that. In the deputies,
I'm taking a restroom break.
okay, in the deputy's report, he stated that he decided or conspired with some of his other officers to not charge me with something else of greater magnitude and only charge me with this. And so it sounds like they have other things out there that they might or could or should have, might have, wanna, could have, were thinking about and maybe come back at me with that I should be concerned about. Should I be concerned about? So am I really off the hook, even though the judge ruled dismissal? And it's been 9 months, so they can't come back and refile
You're off the hook,
that
bro.
same charge.
With or
I
without
know,
prejudice?
I know.
Yeah, that's what I was going to ask. With or without?
Oh, I'd love to have them come back. This has been fun. I mean,
Is it
I love a good fight. I
with
love
or
a fair
without
fight.
prejudice? With or without prejudice?
Well, it was just dismissed because it's 9 months, and 6 months they can't. They can't. After 6 months, it doesn't matter if there's no prejudice or non-prejudice because they can't refile
Right.
within.
But what did
They
what
can't
did the
refile
judge?
that. They
What
can't
did what
refile
did
that same thing, but if they charge you with something else,
That's
then they
correct.
could.
Now, wait a
That's
second.
Right.
What's
So
interesting? What's
that's what
interesting?
I'm thinking. What is it that they could charge me with?
Well, this is the thing.
Reckless
Listen,
Oh, they
we
can
gotta see your actual dismissal. We haven't seen your dismissal yet, right? We don't know the paperwork. So the paperwork coming from the appellate court, I don't think it's going to be the same as the paperwork that you're going to get on the lower court.
Well,
Because the
I
appellate
don't
court is
know.
looking at the distinction of what happened on the lower court and how the lower court applied it to you. You see what I'm saying?
I do. I didn't get anything when I left, but I have the paperwork that I submitted that I hoped the judge would have just signed rather than try to create his own
On a proposed order? You talking about an
order?
order? Yeah. Well, I think one thing you probably could request, though, is an order with factual findings and conclusions at law, if you'd like. Even though it's been dismissed, you could request that from the judge. And I think that would be something that would be beneficial to obtain. And I think
Right. I want to frame
the
that.
judge, yeah, I think the judge would probably write it out if you request it in a nice way. I think honestly they if they get a nice letter from you that's requesting that, or I think they would look at it like, yeah, it'd be cool for me to write something out in relation to this. Especially, bro, you're 79, so people gonna honor and respect you, for sure, as you should. Like, bro, you made it to 79, bro. I hope. Like, come on, man. Thought I was gonna die younger than this. Damn, it's crazy. So,
Well, I look at that this way, Cam. I'm in my 80th year.
it's lit, bro. Like, what are you talking about? You know what I'm saying? So, yeah, man, it's really cool. I'm so glad to know you. I'm so glad that you're the first operational Wisedome member. I'm so glad that this happened to you and we was able to help, support, and be a part of it. And I just want everybody to say congratulations one more time to Bob. Everybody, please, can y'all?
Yay,
Love you,
Bob!
Bob.
Good job, Bob.
Good job,
Way
Bob.
to push through
Congratulations.
and stand firm.
So you're all
Right.
invited
Thank you, Bob.
here to the river if you ever get in the neighborhood.
Hoorah, Bob! Hoorah!
Might see you in July,
Thank you,
Bob.
Bob.
What do you think, Cam? Go see Bob?
Bob's got it, bro. I think irreparable harm is definitely in place. That's for sure. And Bob did a lot of work. Bob did a lot of work. studying, getting ready, trying to figure out which situation. It seems as though all he had to do was attack the statute.
When
And I
can we get
guess
a video of him popping off some shots across the river?
probably next time I go out there and
Yeah.
goes out there, you know what I'm saying?
Dress him up like Bob. Dress up like Rambo with a bandana, the knife, and go out there with a gun. Predator.
my mom was a pacifist. My dad was a Purple Heart winner when I tagged out a German Nazi SS officer. We never had a firearm in our house because mom ruled. I never bought a firearm, owned a firearm until I was over 70. And I bought it because I was a car guy and had hot rods. And now my back and my fingers and kind of stove up. And now I can sit on my back deck and just practice shooting holes in the river and haven't drained it yet. I killed a bird when I was about 9 years old and still regret it. Have never killed another thing intentionally since, except a snake.
Well, you killed a big snake this time too.
Yeah, you did. He did it, man. He literally did it, bro. And we're so proud of you, bro. For real, for real. You're doing great things, bro. And you're definitely an American, showing what is it, magnanimity, which is the soul and essence of what it means to be truly honorable in all forms and fashions. I think honor comes in a lot of forms and fashions, and sometimes we got to fight to receive that honor that we deserve rightfully, just by existing. But if we continue to just stay humble, focused, non-belligerent, non-combatant in this thing like we always do, I think we're gonna continuously progress in achieving the moral unity and gratitude that we all should have as life is, because this is so short, bro. So like I said, yeah, there's a couple.
I finish this. My dad's grandpa died 2 months before my dad's dad was born, and my dad's grandpa fought in the Civil War because they burnt down his farm, his dad's farm, because they spoke out against slavery. His great grandfather fought in the American Revolution and two of the battles that turned the whole war in the South. Look up Battle of Kings Mountain and Battle of Cowpens.
Cowpens?
Cow, Cowpens.
Cowpens, it's like what?
In Cowpens, Battle of Cowpens, and Battle of Kings Mountain. And then Daniel Putman, went on to immigrate to Indiana, where he became a judge and died of 1816 of the influenza epidemic. Think COVID 1816.
Right.
But he fought in the 1812 war also. But my great grandfather fought in the Civil War. His older brother left and came to Oregon in 1847, one of the first 12 or 9 families here. So I yield.
See, I wish I knew my history like that. I don't even know my genealogy history like that. My mom was adopted. And then my mom didn't stay with my pops. I know who my pops is, but then when I reached out to him, he didn't even wanna connect like that. I know my sister. I reached out to her. I know my brother reached out on that side. I know to him too. It's crazy because like my sister, she was the most responsive to everything. My brother, he like, well, my biological father, he's like, well, he don't really want to talk to people like that. That's just kind of how he is, Like, damn, all right, cool, like whatever. And then so I just accept it's what it is. Yeah, it ain't shit, But it's cool to
accept it, adapt to it.
Yeah, I know. I just want to know more of my lineage. That's my thing. Like, I want to know more of, like, even if he don't want to connect, like, I want to know what's the backtrack of us, because it's so weird. Like I am where I'm at in my life, and building empowerment within people. Right. I'm. It's like I'm succumbing to God's will because this wasn't my life. It just got given to me. Like here you go. It wasn't the plan. It was just like boom. You need to do this. Oh, what? This is crazy. So like my life was cool, bro. I was chilling. So minding my own business. So yeah, to come into it like this is kind of weird because man, what was I about to say with this though? Damn it, I had a and it just slipped my mind, bro. Like, I wanted to know my genealogy because my sister, she worked for Obama, bro. She was in the White House, bro, the whole 8 years.
What?
Yes, bro. She was the head makeup person for everybody in the White House, the whole 8 years.
Wow.
Then when Obama was done, then she went and worked at CNN as the top makeup person. Now she's just sitting back doing like real estate, I think. My brother, he first round draft pick, Baltimore Ravens. He's still is on the Ravens right now, first round draft pick. I think I got another brother named Cameron. So like I'm trying to figure out my lineage because I already know that like 80% of black people here in America are from America and not from Africa. And so, like are the, I know the truth of that. So it's kind of like, I want to figure out where my lineage goes. Like I understand that like we got the last name Bullock. So it sounds like we coming from more of the black Irish type vibe. See what I'm saying? Bullock. Okay, if you really want to say it. So it seems like I'm coming down from the Irish type vibes, but I still want to know, bro. I still want to know. I wish I could. Anyways,
like Sandra Bullock.
1 L. I think it could be 2. I think it's just it's Bullock.
There was a story I remember when I was a little kid, and my grandma was still alive, which I was raised by my grandparents. I got curious one day, and I asked her. I said, "Why are you scared or don't like black people?" She told me, and she was born in 1921. She seen the first automobiles, all that, went through the Depression.
Yeah.
And around where I live, this part of Western Kentucky, she said there used to be gypsies. They wasn't black people, but and she didn't know it then, but they were real dark skinned. And the gypsies back then, if they come up to a house in the middle of nowhere, they would go in, kill people, rob, steal everything. So she just by default, and I come from a racist family, and I've always thought since I was a little kid, man, this is wrong, when I started going to church and everything. And that's why I asked her, it's like, why don't you like black people? And on this part of the country, that's where racism comes from, ignorance. Just plain ignorance. And I think it's cool that if we look at history, our forefathers and they did the fighting and shed the blood, so we wouldn't have to. We can use a blue ink pen where they got physical and shed blood. I think that's something really cool that how things have come to.
As they should have. Hey, did y'all? Let me ask y'all this real quick. Did y'all hear of Angel's court hearing? Did y'all hear of Angel's court hearing? Did most of y'all see that or no? No, Chris. What about everybody else?
I saw.
Oh, the girl, the blonde-headed girl.
No, Angel. Nobody? Not really? Okay.
No,
I saw. I watched it.
Yeah, let's hear this real quick. This is crazy. This is just crazy. I'm gonna skip through it because it's 11 minutes and there's a lot of gaps, so I can just skip through the gaps. But watch this.
Angel Manuel Morales on CR 250178887. At this time, let the record reflect that Mr. Morales is present for the purpose of this hearing. We also have a deputy present. Today is set for a bench trial at 3 o'clock. At this time, the court has been calling for a prosecutor, and we have been waiting to see who is going to fill in or appear, but there's no one here.
What are you talking about? There's no one here. We're in the courtroom. Is there no prosecutor? Where are we at? Where are we at to where there's no prosecutor in the damn courtroom? Where are we? This is not real. This is not real, bro. This cannot be real. This got to be fake, bro. I don't know where we are. It must be like what me and Bob went through as far as the justice court is concerned. We're in a shopping mall center because this is wild.
For the record. And I just wanted to explain.
But like she said, it's for the record. So where are they?
To you, Mr. Morales, I know you had requested for a bench trial, the court set for a bench trial. Then you filed a motion for an evidentiary hearing. So I just wanted to explain that with you because I didn't receive motions for the evidentiary hearing to reset. So I didn't see anything on reasonable suspicion, for example. I didn't see any of those things filed. That's why I wanted an opportunity to have this hearing and move forward. But the court can't move forward without anyone here, unfortunately.
So I move the court to issue an order to dismiss.
Mm-hmm.
Give me one moment.
Angel only been working for a month now, by the way. Oh, Angel only been working for a month, as you see. Only for a month. But where else we got him at? Angel. Let me get to Robbins too, though. Robbins is crazy.
So like you can just motion the court to dismiss.
Yeah, orally, just like that, yeah.
Wow. Okay.
Is that the prosecutor?
Oh, this is Robin.
Ah, okay.
Angel.
Judge, it has to be the same prosecutor that was dealing with the case, wasn't it?
No, but
I mean,
Mm-hmm.
is there something that somebody walked in that I need to sign?
Yeah, he was ready. Look at him.
Do I stay on the record? Yes.
Yeah, let's go, baby. You already know what's up. All right.
I remember watching this now because at the end of
Is
the
it just now
video,
one form that I'm signing? But it looks like they
it
changed
shows
this
that
for all these,
judge trying to pressure him.
Yeah, he gets on her ass.
verified party, no person knowledge of the facts to proceed based on the
Okay, and sir, so is it just one form that I'm signing now? Oh, okay, then rather than signing the ongoing?
Yes, just.
I see. Sir, okay, I'm going to ask, sir.
Liable for any further trespassing.
Sir, a supervisor is coming to the court who is the supervisor of the prosecutor. Okay, and the court has to wait and do their due diligence.
Just doing my objections.
So there were three forms. I didn't see that. Okay, thank you. That was new. All right, thank you.
Thank you very much, Judge.
They're quiet for a while.
I got two very honorable. Thank you. We didn't think you were coming back. Yeah, you never went back in the interview.
Can the judge just ignore his motion?
Thank you.
Like that without addressing it?
You'd like to wait for the prosecutor to be here.
They're not waiting for me. They're not on time. I don't have to wait for that.
Okay, well, I need to wait, and I'm graciously giving them another 2 minutes here, okay?
Okay.
See, Angel's cool. He's like, I don't have to wait on them. Like, and she's like, well, we're gonna give him 2 minutes, you know. And he's like, okay, and graciously. That's you know. So you can see that there's current dialogue between at least him and he's. I feel like he's a little bit too pressury. Me personally. I'm a charmer. I want everybody to smile and laugh at me when I leave. Okay, they want me actually to stay because people don't engage with him like that normally. That's how I want to leave the courtroom, right? Very charming. So with all this graciously, I'd been like, oh my gosh, this is crazy. Like, what is going on? Like, why are they not showing up, Judge? Like, what you? I'm building some controversy now. Now we're gonna build a little. What is it? What is it when people talk shit about each other? We're gonna gossip a little bit. I don't normally gossip, but yeah, we're gonna gossip now, right? We're gonna create some, something to, need, man. I'm building
dialogue.
Yeah, I'm building some kind of relationship.
This is what's the most aggravating. The judge knows, like they just said, they can't proceed without prosecution. If the prosecution's not there, it should be immediately dismissed.
Right.
But we'll just wait. See, this is what they do. Same with the competency. Same with all of that. And this is what's the most frustrating is if it's on you. Oh well, you have to do this. You have to bring these things up. You have to invoke all this stuff. But the reality is, it's on them. If they weren't allowed to file incomplete briefs, none of us would have any of these problems. And now it's on you to go and defend on a case that they can't even present properly to even have standing in court in the first place. But see, and I've seen it. I mean, shit, I don't even know how many times I've been to court now. 100, probably, close to.
So I'm sorry.
They literally do nothing. They'll call a hearing for X, Y, and Z.
I go to that hearing, X, Y, and Z is never even discussed. They just go on to something else. Like, yeah.
So can you have the judge recused for not following procedure in that case, for not automatically dismissing the case?
You could bring it up, but see, here's the problem.
Wait.
The judge can
wait. Who all in here has gotten a recusal? Who all in here has been able to recuse a judge?
Not me.
Joe.
Who all
Joey
in here has
yelling
been
like
able
a
to
bot.
recuse a judge? Yeah, y'all speak up. Who all in here has been able to recuse a judge?
I have.
Not me, not yet.
Who else? Nobody else? Just Sarah?
I have multiple times.
Okay, you're right. What's going on? Who else? Not Rich, not Robin.
Joe Fly Daddy.
Joe did. Joe ain't in here no more. He left.
Like a boss, if you ask me.
We've had a lot of recusals, bro. We've actually had a lot of recusals. There's been a lot of them. So recusing a judge ain't really hard. Lana had gotten a judge recused. It's not hard to recuse a judge. You just got to pull out some of their bullshit that they be doing, and their bias in ways. So, it's not
What
hard.
is it? When the prosecution doesn't show up, it's on us to move to courts in order to issue the warrant or sanctions against them for not doing their due diligence or duty. Also,
You know what? That's crazy to think about like that for real, though. That's crazy to think about like that for real. You know, that makes it be where it's like it's a failure to prosecute. So that's already a violation. But like, yeah, you really gotta think about like, if I don't show up, you gonna arrest me and do all this other shit. But then you can just come here and waste my time. That's crazy.
Another building?
Yeah, how do you handle that though?
I don't know. We're gonna have to
Because
look
that
into that.
happened too.
I don't know. We're gonna have to look into that. I got Angels. Like I said, I got Angels' case file built up. We built up. Look, we built up.
So
I don't even know what all he filed, but we are built up. It's crazy.
so
it'd be just you moving the courts to place the order of sanctions for the prosecutor not showing up. Basically, they got a duty to be there.
Say if a judge got so furious, got up, walked out of the courtroom, what would y'all do?
You know what? I have his, and I don't know if I threw his
I
up.
would dismiss that case on my own.
Hold on,
The
let
record
me.
reflect
In the
that
court,
is waiting
under
and
common
allowing
law,
an
and
unverified
dismissed.
party. It's 15 minutes later from my court trial, and I moved the court to issue an order to dismiss all charges and to release detain. Excuse me, I'm on the record. You're speaking over me, sir. Excuse me.
He humble. Angel don't play. He's like, excuse me, you need to stop talking. He's trying to talk, and homeboy's interrupting him. Let me take it back down speed though.
Let the record reflect that I need for the court to move the court to issue an order to release any detained property and to dismiss all charges. They lack subject matter jurisdiction, and I'm the living man, not the sole proprietor or the fictional person. On the charging instrument, they have.
Yeah, I wouldn't have mentioned all that. Me personally, I'm not coming in talking about I'm the living man and not the corporation. That's me. I'm not gonna come through there mentioning that. I think I've already established that through my paperwork that I'm there by special appearance. Yes, if he's trying to dismiss, just say I motion the court to dismiss. The prosecution is not it's not showing that they're willing to prosecute in any form or fashion. I just want to bring this into the record, and just chill.
And at this time, I'm going to go on the record, so if you can let the judge talk. So at this point, sir, as I pause, it's waiting on 15 minutes. I'm not sure what happened with anyone. The court is dismissing without prejudice. However, with that said, the county attorney's office may refile, and that is their discretion to refile. Okay, I'm dismissing because I have no prosecutor. I'm going to have to relieve now the deputy who did appear. Nobody showed up by Teams. We've been calling or in person.
Thank you.
So we're done here.
Can we issue the order in writing?
What does that mean then? What does that mean? What is going on? What does he now pursue? Civil action. All of these things, like, people don't understand, like, just these little actions of bringing you to court is a violation of life, of your liberty.
This
When it
is
wasn't
where she
supposed to-
tries to force him out too.
Yeah.
About releasing the property and everything without conditions?
I'm not sure what property you're
You're
referring
sure?
to.
It was in the charging instrument. I have the VIN number right here.
I have nothing to do with any vehicles that are.
It's a part of the charges. So let the record reflect that the judge's not giving a written order to dismiss the
I have
charges
nothing to
with-
do with the company, sir. So if you
So this is where I would say there's a controversy here that really shouldn't be a controversy. You should be the charmer, bro. Like you want to be the guy that's getting them to love that what they're doing, is for you. So you want to be like, when she says it's motion to dismiss, thank you, Your Honor. I really respect that and I appreciate that. I was wanting to see if there's any possibility that you could give an order with factual findings and conclusions at law. So at least that I can have that in relation to any kind of monetary or later litigation issues as far as civilly is concerned in relation to the obstruction, or should I say the taking of said property of the VIN, which is currently on the charging instrument. I just wanted to see if you could help me out in that manner. They're going to come back, bro, in a form or fashion where they're going to say yes or no, but it's going to be way more polite than.
you have to take your car out of impound, that's why I gave you an attorney to begin
You
with.
are interrupting me while I'm putting
Okay,
things on the record.
so
Whoa. Now we're getting into interrupting, and that's you don't want to have that look. You want to have a very honorable, respectful interaction, okay? As much as possible. Because right now what you're doing is you're causing a controversy to where the judge don't want to even go that extra mile to really give you that written order. You see what I'm saying?
we are done here, and I told you
I'm
that
not- I have the
before.
right to address the record, man. They were not finished.
We've already had that discussion
No, we
about
have
your
not.
vehicle,
I need it on the record, and I
and
need
it,
to
and it
document
was
that.
on the record.
Let the record reflect that. Let me state my whole process here, because you know what? This is not done. Okay.
If you're going to wait another 5 minutes, she's
Homeboy got the dismissal and he talking about we're not done here. Whoa, hey, let it be done, my guy. Yeah, let it be done.
So
And
Cameron,
submit something into the record as far as a letter is concerned for a
Yeah,
request.
that
You
was
ain't gotta do all-
crazy.
Cam,
That's freaking crazy.
what would you do to get the car back?
Huh?
What would you recommend to do to get the car back?
What? I'm buying a car. I'm paying for that.
With
paying
the
for
money
that.
from the case, right?
I'm paying for that. Whatever I got to do to get my car, I'm paying for that. Guess what? We're going to come for that
Judge,
later.
or judge, please, beforehand, I'm not a bar attorney. I'm not sure all the navigational procedures how to get my vehicle back. Can you please state something in the order that my vehicle should be returned?
Correct. But I don't think
About
Angel.
property.
I think Angel already had his property back. I don't think it was still kept from him. I don't think it was still kept from him, for real.
going to be here, and I'm going to have to
I'm not
reopen the
waiting in.
case.
You already dismissed it, and I have to address
But apparently Angel likes to argue.
the record. Let the record reflect under the First, 9th, and 10th Amendment to the United States of Constitution. I am exercising my inherent right to speak, declare my status, and establish the jurisdictional prerequisites for this proceeding. I do not consent to any statutory definitions.
Now, wait a second. Why is he reading this? It's already dismissed, bro. What are you doing? See, this is what I'm talking about. This is what I'm talking about. He ready to just bring stuff into the record that don't even need to be brought into the record right now, bro. You can bring anything you need to into the record, bro, by a writing. Why are you arguing? And why are you lengthening out this hearing? The prosecutor may walk in and they just gonna say, "Oh, prosecutor's here. Let's get it going." And you, no, you already dismissed. Well, you know what? We undismissed that bitch. They do some shit like that if you don't stop. What? Boy, get your ass up out of there.
Legalese or terms of art used by this court or the state. Any use of such terms by me is in their common meaning. Everyday meaning only.
Ms. Walker,
It's not necessary.
for the record, I
It's not necessary. You see what I'm saying? Why?
The record reflect the judge continues to interrupt
again,
me.
sir,
I'm finishing my
I am
status
now
under
speaking. We're
under
done.
the First Amendment and the Second Amendment. I have the right to declare my status before
okay,
you
you can
even
write it.
speak.
You can write it in the motion.
Oh, there you go. There she said it. She even said it. She gave this nigga legal advice. You can put it in a motion. Okay? If you want yourself to be heard with all this stuff that you're saying, put it in a motion.
I don't have a motion. Right now we're in court and you have me here.
Okay,
You wasted my
so
time.
right now I am speaking.
I do
Ms.
not,
Walker, I've been waiting for
explicitly
the county
reject any
attorney's
and all
office to
presumptions
Oh man, they're speaking over each other. This is crazy.
here
meanings
for the
that
past
would
15
imply my
minutes. I
consent to this
dismissed without.
What?
Bailiff.
Yeah. Bailiff, get your ass back in here, bro. Deputy, get your ass back in.
contempt.
Yeah, for real. If you don't sit down, chill out somewhere, bro.
jurisdiction or
30
join
jail,
the
30
artificial
days in jail for you.
I'm telling you, will not chill, April. I don't know what's going down.
About his vehicle that I have no control over. So
It's part of
that's
all the
impounded.
arrest. It's part of the arrest.
So we're done here. So
This is the disclaimer
at this
and
time,
made
if
under my
officer can
reserved
take him
rights.
out,
Let the
we're
record
good.
reflect on
Oh, there they go. If my officer can take him out, Bailiff!
Under the 9th and 10th Amendment to the United States Constitution, I hereby appoint the presiding officer, the prosecutor, and all officers of this.
That's it.
So,
That's
so,
really,
so
for
Cam,
the record, cut him.
so Cam, so in his case, he's trying to get, I guess, remedy for them taking his car, right? And she's saying that she has nothing to do with them taking the car. So would he have to file a separate lawsuit with the company that took his car, or with the police department that?
Yes. I would file a small civil suit against him. I wouldn't do like a federal one. I would just do like a civil claim against his ass, or their ass.
Well, what about what Carl Miller talks about when he gets a case dismissed and he has to be compensated for defending a frivolous case?
Right.
What would something like that look like? That might have been more appropriate in this case.
Bill for damages.
They didn't show
in
up.
your brief. Is what Carl Miller did.
Well, they didn't.
I get what he's saying, though. He's trying to get the judge to do what the judge should do anyway. So I get it. I also understand, just take the fucking win and leave. But at the same time, all the shit that these people pull that they don't do that they're supposed to do. And here's one where they dismiss the case. Okay, cool. So why not release the car? Because they should. But they turn around and claim, oh, well, that's not, I don't have any say over the towing company. Fuck yeah, they do.
Yeah, you do.
So I get
you
it.
can simply say it. Please state it on the order of dismissal to release the car until such time as the prosecution brings another charge. Kindly, in the interest of justice, I've already been irreparably harmed, Judge. It's something you can do, please, and thank you. Right? Am I missing something?
See, so he does ask for it. When he talks about it in that transcript, he says, motion. Carmela says, I'd like to motion to dismiss, Your Honor, failure to state a claim for actions in which the relief may be granted, and I'd kind of like to collect my costs and fees for having to defend this frivolous matter, or frivolous case. The only problem is he never explains how he went about it. As far unless they were just to establish it there, which I don't think that ever has happened. Me personally, motion granted. I'm telling you, the effect changed.
See, because it's all about. I mean, think about it. It's all about court bullshit, man. So if they can dodge that and just get you out of there, then you have to go down and you have to file more shit now, don't you? Which means another case. So it's all about money for the court, you guys. That's what it is. That's why they do everything that they do. So if the judge can just dodge that and just say, "Oh, well, I don't have any control over the tow company," that means the guy has to go file another case now, doesn't he?
That
means the court for money whether they do criminal, right? And then collect off that, or make you come back to sue the tow company now to get your car. See, so it's all money. Set you up for another court date.
Could he have done a countersuit in that same trial, although it's been dismissed?
They'll claim, if it's a criminal thing, they'll claim that you can't countersue.
But it's clearly a civil suit. Would you have to argue that it's a civil suit before even getting into the litigation to begin with?
With who? The tow company?
No, because they would argue. He's saying that they're arguing that it's a criminal case, but it's civil, right? He hasn't done anything criminal, right? There's no probable cause, so he hasn't done anything criminal. It's a civil case. So would you have to argue first that you're not even arguing in the right type of case? Like this is actually a civil case, in which case I can seek remedy.
Could, but they're going to claim it's criminal anyway.
Yeah, but they don't have probable cause. You haven't committed a crime, so it can't possibly be a criminal case.
Right. Well, but see, here's the thing. In court, it doesn't matter. If they claim that it's a case, then it's a criminal case because that's what it was filed as. So, yeah, like here before I. Well, no. See, that's the point. See, to me, this is what is the most aggravating. Having to rebut all the shit. They don't even file complete briefs, so they're not following their own rules. They don't do anything that's required to even bring a case because they know they don't have standing to sue anybody. So they'll just, oh, it's a criminal. And that's it. And then the judge will go along with it. They'll all just go along with it. They know. I mean, shit, dude, I stated this stuff on the record in the Eaton County that the criminal prosecution must be tried or prosecuted in the name of the victim.
Right. There's no victim.
There's no victim. On every single court paper, no victim. There's a complaining witness. No victim, no. They're in the victim box. So they just go along with it. And I mean, and it doesn't matter. In my experience, none of the shit that you filed matters. In my experience, none of the motions that I put forth or had hearings on mattered whatsoever. They just took those and fucking twisted them into some other bullshit that wasn't on the docket, that wasn't on a motions hearing, and every single time. And they always fall back on this competency bullshit and then hold me in contempt and then fucking blah, 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 blah.
Don't give up.
Don't give up, man. Don't give up, man.
Where's Robin's video at? This is crazy. I don't see it.
You tried going to a higher court?
Because, I mean...
I didn't give up. I had to fucking out to get out of jail to stay more effective.
Is it even possible to argue their jurisdiction as far as, like... Because, again, it doesn't make sense to me that... Say I get pulled over for traveling, right? I'm traveling, that throw you in jail. There's a silly case, and they're like, you're a criminal because it's a criminal case, and it's like, who's the victim? What crime did I commit? Like, how can you try me as a criminal if I committed a crime and there's nobody who got?
Because the state's, like the judge told me, the state's the victim. There you go. That's the victim.
Impossible.
Well, that goes against the Constitution.
Victim on the document.
In the Constitution, it says they can't be the trier, the charge and trier.
Yeah, lots of stuff they're not supposed to be doing. In the Eaton County case, they used a document for the warrantless arrest. Okay, they used a document that's clearly intended for parole and probation violations. I wasn't on parole or probation.
So why didn't you recuse them? They're clearly not.
Put it in motion, bro. I told you, 2 courts. Okay, 2 different judges. Actually, in Eaton County, there was 3 or 4 different judges. Mm-hmm. And they just do whatever the fuck they want. They didn't address any motion. They didn't
went to the higher court.
Yeah.
Hey, Jack. Okay, Jack's got his hand up. Jack, go ahead.
Oh, so I just want to speak on the whole collecting costs to the prevailing party when you're dismissed. I tried that once. I didn't have the time to do such in-depth research, but typically you want to look at your criminal rules of procedure for that county or, the jurisdiction. And they'll talk about if you have a lawyer, but there's usually one where it says something like if something's not shown in the criminal rules, look to your civil rules. So you want to ask AI to search through, or you search through it yourself if you want. But in mine, since I had been to the court too many times, and it's like this is the last time I'm gonna be done with it. I just did, hey, look, here's the criminal rules. It says, it doesn't have anything about me getting paid for coming here and collecting for, my labor and time and such. And then I showed them the civil rule that would apply. And the judge said something like, it was some kind of bullshit thing trying to say, oh, well, it doesn't create a new avenue. And I'm like, frankly, if I had done more research, I would have been like, yeah, it does. But that's what you guys want to look for. If you're going to be a defendant for some minor traffic violation and your shit's going to get dismissed, look up the civil rules of procedure and put that whole PDF into AI and ask AI, like, in your scenario, being pro se, is there an avenue for you to collect money in a way that a lawyer would? And the AI is going to say something shit like, well, you're not a lawyer, so you don't get paid, and then you want to put in your civil rules and look at that kind of shit.
What I wanted to tap into real quick is Robin. I don't know if y'all know about Robin. Robin's been around for a little bit now. He was in Miami Beach where he was just sitting in his car. Here,
Yeah,
let me
I
show
remember
the
that.
situation real quick. Just real quick.
Him and his boy.
You can see in his hand he got a ticket right there. So there's no issues whatsoever. They finally wake him up. Look, homie's asleep. Dead asleep. They both dead asleep. They tired.
Miami Beach Police, open your door. Police. Open your door.
He said, "What's up, man?" He said, "Why?"
Miami Beach Police, open your door.
2188. Line of business 15 with 2181.
That's 419. Does anyone have a vehicle?
What's going on with you, man? Get out of the car.
Whoa. You just open up the door. What'd you open up the door for? What did you open up the door for? This was a caretaking stop, right? Y'all claim it's a caretaking stop. Why'd you just open my door?
You're in the center?
Why didn't you actually establish
Why'd y'all just
Robin
open the
saying
door?
we don't need medical attention.
Look, he's just leaning
They
on
done
the door.
opened up Robin's.
All right. Why are you sleeping in the car?
Why are you sleeping in the car? That ain't none of your motherfucking business why I'm sleeping in the car. Leave me alone. I'm not answering none of your questions. You got my door open, bro. Close my door with your illegal grabbing ass. They already grabbed the gun, I think.
Yeah? Is it because you had a little bit too much to drink? No, then why do you have an open container in the back of your car?
Don't worry about it. Don't worry about it. That was left from when this girl came. She was in the car. We was doing whatever we need to do. Don't worry about it. Ain't got nothing to do with you, bro.
That's not my question. Why do you have an open container in the back of your car?
Bro, I'm not answering any of your questions. I reserve the right to remain silent. Please leave me alone.
I didn't ask if you called me. I am asking you a question.
Look, it's harassment. So homie said, I didn't call y'all to help me or anything like that. I didn't ask if you called to help me. You see where this is going, right? This is not finna fly in no trial, no real evidentiary hearing when I get to cross-examine this dude. I know that, look, this is what's going on. All right, so we got this going on, right? This is the situation that happened.
Answer my question. Why do you have an open container in the back of your car?
This is how they acting with homeboy, but I wanted to show y'all the coercion of trying to convince this young buck over here that's a new boy on the police force to participate in illegal arrests. Okay, there's a convincing, it's kind of like an initiation of the Blue Line Gang type vibes. You can really feel that. I know I could present that in a trial if I needed to. It's real sus, right? In the evidentiary hearing, only this
I
guy.
already cleaned that. Oh, yeah, I cleaned it. It's ready to put that.
All right, watch out now, girl. What are we doing? What you got going on? Is you shopping? All right, I'm gonna mute a homegirl up. And what's crazy here is that you can see the pressure that's being given to this cop to engage in illegal activity, to see if these cops can trust him when they need to pull off some illegal shit.
Yep. And if something goes awry, they can blame it on the rook.
Yep. That's exactly what's happening here.
Everything that I say.
It sounds funny, but
it's so true, bro. It's 100% true. They're caught red-handed on this one. Look how nervous he is. His face and shit.
Okay. Then you got this cop over here on the right. Okay, so
100%. Then let's do it. Do you want to do it?
See, he's saying it's 100%. He said, homeboy said, well, then let's do it. He's like, well, let's do it. You can do it with me. Like, I don't need to be like the one to initiate it. And he's like, do you want to do it? Right? Homeboy's throwing it off on the youngster again.
Why would you ask? Do you want to do it? It don't make sense to me. The lead cop in this situation is the person that we're watching, but yet he's pushing it off onto this younger cop.
Do you want to do it? Let's do it. You feel comfortable?
Y'all are all saying let's do it. Let's do it. But this cop is asking, do you feel comfortable?
Yeah.
This is the initiation.
Yeah.
This is the initiation. I'm telling you right now, that blue line gang type vibe, this is that initiation. Okay?
Yeah.
They're pulling in
Exactly.
a new one to be like, hey, can we trust you? Hey, can we pull you up in this thing? Hey, let's
Scary,
get you,
bro.
you know, when I need you to,
Pretty well.
when I need something to put off on you, you gonna take it for me. You see what I'm saying? This is that initiation.
You have
And when you're there, no, we'll be there for you with some other bullshit.
this guy
Yep.
is drunk. You can do SFSTs on him. Okay? Because he's behind the wheel. You can DUI him. All right?
So see, he's trying. I'm sorry, I got to pause again. But you can see he's trying to convince him. You can do FSTs on him. He was behind the wheel, right? Bro, he was not operating the vehicle. He was dead ass asleep in a parking garage. You cannot arrest him for DUI. The fuck are you talking about?
So do you want to do it? Do the DUI. I'm on.
And then he goes, listen, and then he goes, I'm on. Doesn't say camera, but flicks the body camera. Do you see that? Watch.
So right here, what you got is him flicking the camera, okay? And he even lets the camera know, my nigga, that he's on camera. He can't do anything. That's what he essentially just did. Watch.
Because he's behind the wheel. You can DUI him. All right? So do you want to do it? Do the DUI. I'm on.
I'm on camera. What sense does that make? How dumb can you be? Bro, we talking about lawsuit. We talking about lawsuit.
That's what I'm saying.
What
Now,
you talking about?
like, what's crazy is I want to show y'all what's going on. I don't know. Robin, are you in here or what? Robin.
Yeah, what's up, Cam? I'm here. I'm just I'm at a barbershop.
Okay, you fine. Go. You good. I'm just letting y'all know. Robin's in here. Okay. The dude that had to experience this interaction, which is a violation of his life and liberty and his happiness. Okay.
So, Rob,
Okay. He's in here, y'all. And he will go to tell you everything that I'm speaking on right now. He's got a private attorney. All right. He's got a private attorney. Now, they've been working on my boy's case, but they still ain't got it dismissed. Why? Why haven't they got it dismissed? Let's go into this little evidentiary hearing that we got of Robinson.
So the hours, right?
Robin Francois, this case, they set it for 9:46.
Your Honor, the state is ready already. Both of our officers are present in the jury.
Okay. I set it for 9 a.m. and they set it for 9:46. Okay. Give me 1 second. Let me take a look at the history of the case because I have one case from October 12, which is a DUI.
Did it switch down there? It better. I need it to come down some.
Officers, I'm going to ask you to please step outside. Do not discuss the case amongst yourselves or with anyone, okay? We'll try to bring you in right away. Thank you so much. All right.
Your Honor, I have a copy of the state's response if you would like.
Sure.
Every time I got to figure out how to get.
Imagine saying this, right? When I filed my motion to suppress in February, right? And imagine the audacity of making that argument about not being on notice when this motion was filed almost 9.5 months ago. To say that now that the state has no idea. So for 9 months, right? They had no idea, didn't put me on notice to say, hey, can you amend your motion? Just like if we did a bill of particulars, the court would be lambasting defense counsel. If I filed a motion for.
Okay. Now, this guy's got a great point, okay? This attorney, this is his private attorney now that he has on an evidentiary hearing that happened, I guess, not too long ago. But he's talking about a bill of particulars and how the state would be lacking. They're already lacking in relation to responding. So I feel like this private attorney is kind of good, and you can learn from this private attorney on some aspects, but where is he lacking? You haven't filed a failure to prosecute, bro. You haven't filed anything that makes it a violation of the prosecution to make this case go ahead and dismiss because of their lack of the response and not following the rules of criminal procedure.
The court
that's on homeboy. That's not on, like, you've allowed it to go 9 months. Why did you allow it to go 9 months? Why have you allowed the state not to respond to you for 9 months then? Why haven't you already filed a failure to prosecute in relation to the egregious violations of you having to extendedly wait? I mean, come on now. The defense has got to fight, and the defense ain't fighting adequately, at least for me and my comprehension of how I know how to push the court to do what I need to do.
Would be lambasting.
Go ahead, Aaron.
can you waive so say you start the court proceedings and then you like I got my private attorney. Can you waive your private attorney and then go pro se?
Oh yeah, you can go pro se anytime.
Defense counsel, if I filed a motion for bill of particulars on the day before the case is set for trial, claiming that I have no idea why the client is being charged, what the specificity is, you would say, why would you wait until now? You've been on the case X amount of time. The information was filed 9 months ago, and now you're saying you're not on notice? Like, how is that fair to me? And I'm telling you now, okay, that was news to me. When I get this motion filed at 6:23, after business hours, yesterday, being told that the state is now somehow prejudiced. Prosecutor after prosecutor has seen this motion. I've begged this court to bring it forth. They even said they would file a response the last setting, which was in October. And you know when they filed their response? Yesterday.
Thank you, counsel. Motion to strike number 1 will be respectfully denied as untimely on that ground. And on the second ground, the state has already filed a response. So let's proceed. Do you have any opening statements? If you're waiving, call your first witness. If not, I'll hear opening.
Your Honor, state waives opening and at this time calls Officer Marcos.
So they waived an opening statement. I don't know why they waived an opening statement. I'm trying to hit me an opening statement.
Do you waive opening at this time?
Just a brief.
Go ahead.
I just want the court.
Yeah, go on ahead then.
We're here for the motion to suppress. The state is the officers came to Mr. Francois on the behalf of a welfare check. Once it was clear that Mr. Francois and his passenger were awakened.
I'm gonna keep it real, bro. The defense on this case right now is actually okay. Okay. What are we doing here? There's a chat. Somebody asked me some. Oh, okay. Y'all chilling? All right, we good.
They were up. They were responding back to officers. That wasn't enough for them to clear the welfare check. So we're here in the sense of, hey, this is the issue. Once the welfare of the occupants has been established, does that somehow give them reasonable suspicion to then order Mr. Francois out of the car and then subsequently arrest him for resisting without, and then make any other post seizure observation? So what I want the court to kind of focus on with the body camera is when, at some point, once the welfare check has been established or satisfied for the police, can they still continue to coerce, engage, and force a citizen out of their vehicle without anything else?
And this is so true, bro. This is the core reasoning behind his situation. Literally. So, I mean, the private attorney actually working on on initial opening statements and things like that as far as arguments are concerned. But what I don't understand, what I'm not understanding is why homie didn't really focus on other violations within the interaction in and of itself, right? This coercion right here is focused for me. That's kind of my thing there. And the false charges. I mean, it's yes, the fruit of the poisonous tree does fall on the position that they opened up the car door. So I mean, literally, seriously, from the point of when they opened up the car door, everything else is suppressed. I mean, there is nothing else that can be admitted. That should be easily. And I'm definitely, as soon as well, wait, I guess.
Okay.
But I just got this week, so this is what we've been working on this week, Aaron. Yeah, this is what we've been working on this week, y'all.
So when you say suppress, so you're saying that, so if we find in the earlier in the litigation that they did something completely illegal and it kind of nullifies the rest of the proceeding, that's suppression. That's all that other stuff should be suppressed. That's what you're saying.
Let me see here. You asked a good question. I'm gonna let Jack or Willie answer, or Doug to answer, or Tony to answer, or maybe Lori to answer, maybe even Rich to answer, or Ruben to answer. Can somebody answer his question? Go ahead and ask your question again.
Yes. So say you find you have evidence at the beginning of this is clearly an unlawful stop for DUI when they're not even operating the vehicle, right?
Sure.
So I'm asking, if you understand that and you bring that forward to the court, you can then motion to suppress the rest of the case, right? The information that's brought forth by everybody else, because the initial basis of the stop is illegal. That's what you would motion to suppress.
Yes, because everything would be if the initial. Yeah, I was say if the initial
his welfare check stop was over.
Right. Well, one,
by the technicality, right?
Bogus anyway, because Castle Rock versus Gonzalez. But even if they weren't, then once they found out that he was fine, He's fine. Yeah, he's fine. He was just sleeping. Oh, okay. No more welfare check. So anything beyond that they did, collected, manufactured, whatever, would be not admissible because now everything that they did is illegal.
Right.
When they opened his door without probable cause of a crime, everything else is
Garbage.
fruit of the poisonous tree.
Yeah.
Doesn't matter. Doesn't matter. They could have found
The
10
recent
million
Supreme
pounds of whatever, and it wouldn't matter.
So I have a second question. I have a second question. So like like they'll make up laws, like they'll say like, oh, the law says this and that, and you're like, bro, go read the statute. Like go read your own statute. Would that
They're
be
allowed to lie.
would that be fruit of the poisonous tree? Right?
No, because technically they're allowed to lie to you during an investigation. Only country on the planet that's a thing, by the way.
Well, here's Tony, that's not quite entirely accurate. Because I think if they misrepresent the law,
that's willful negligence.
Because there's a lot to lie to you in order to get you to get a confession, but if they're misrepresenting the law, I think there should be some type of
remedy.
Repercussion, remedy to that.
If
There
the
should be.
officer puts that in a report and signs it stating that that is true facts, and he signs that report under penalty of perjury, and he lied, you got him.
Okay.
Then that's perjury. But see what they did on mine was
go ahead. Sorry.
The arresting officer made. Oh, go ahead.
That's under color of law, right?
Yeah, it's under color of law. Tony, go ahead. You got interrupted so much you broke up. We couldn't hear you.
So what they did on mine was the arresting officer writes her little report. That's the very first video that you did, Cam, on the 1,000 marathon or 1,000 signature marathon. Mm-hmm. She writes her little report. Then to get it to court, her little report goes to her supervisor. Her supervisor signs it, quote unquote, under the penalties of perjury. So right at the beginning, this is how they cover each other, right? So when it goes to court, and it's, to even get it to court, it has to be under the penalty of perjury. That's why her supervisor signed it under the penalty of perjury. So when they call her, she's not even testifying to her own statement, because the paper that got it in was the supervisor signing it under. So that paper would only bring him in to say, that's what she said. I swear under the penalty of perjury that that's what she said. So it's literally testifying, or, to hearsay, but this is how they cover each other. So then in court, that can't be used against her because it wasn't her statement under the penalty of perjury. You understand what I'm saying?
Yeah. One thing I want to bring through as far as an answer to Aaron too is that, when you bring forth, when you're bringing forth, great documents, which is forcing an evidentiary hearing, then there's going to be, and you're asking for a suppression based on certain things, and you've gone through all the question and cross-examination through an evidentiary hearing. The court's supposed to issue out something like this, which is an order on the motion to suppress. Okay. And within this motion to suppress, she's viewed the video with you. You've cross-examined this officer. You've gone through essentially a suppression hearing through evidentiary. And after that, the judge is supposed to write out their facts, factual findings, conclusions at law, right, on what they felt, how the evidentiary hearing goes, and where is the fruit of the poisonous tree, and where they're not going to allow any other further evidence because of a certain constitutional violation on the forefront, right? And she even goes into, at this point, defendant begins to look, center counter, the continues tug of war because homie didn't want to let go of his insurance, and right, she's pretty much going through everything. Now she finds certain reasonings for certain things, goes into those facts. I don't know why it keeps just like going over like that. It's weird. Oh, because I got it like that instead. Okay, so we scroll down, but what you'll see is in the conclusion here is that the motion to suppress was actually granted. Okay, it was granted. We got that bad boy granted, like straight up. She did it in certain ways and let that be known up front, but in other ways that we asked within our prayer for relief, she denied those. But she did grant the motion to suppress, right? Let me see what else we got going on. So then, yeah. Either way, that's what we get granted once you file an order to suppress. But also is that even when sometimes the judges give certain orders, and we don't necessarily agree with those orders, like she gave a granting, right? But even though she gave a grant to us, we were still able to identify how the court actually was erroneous in some of their factual findings and conclusions at law, which they gave to us. So even though they gave us an order and said, yeah, we're going to give you this motion to suppress, like you're granted, you're good to go on being suppressed on everything else, but this can come in, right? We still came through and was like, excuse me, there's some errors that you made as far as your reasonable suspicion, and then coming through with other actual things that do not support the court's findings. And what we're actually going to find out is that this happens all across the board throughout the United States. Okay, this was in Florida, still, again, another Florida case, but Robbins is Florida too. And what you're about to notice is that, and it's kind of wild, is that in the end of this, the judge actually states a certain case that is applicable, that is in favor of Robin. In favor of Robin.
Is it Rodriguez versus United States extending the stop beyond a de minimis amount of time?
No, it's a Florida case, and it's Taylor versus State, and it's almost exactly like Robin's situation. I mean, exactly. The court's already determined what should happen in situations like Robin's, and it's in favor of Robin. They should leave him the hell alone. But the court states that case that's in favor of Robin and says, "Oh no, wait, that's not applicable. I'm not applying that one here," because she's been studying it apparently, and then goes over and references another case that isn't nothing like Robin's. Nothing like Robbins. And what you see here is an egregious violation of the judicial duty that the court has, which is so prime for a recusal and disqualification. So prime. This judge has got to go. Because the record clearly reflects how you know that there's a case that's applicable to me, and that how it's exactly the situation, and everything should be denied, and I should be able to move around here. But yet you've gone to a different case. It's so crazy that we got the record. It's wild.
And I'm looking for my welfare check case law. That's why.
I'm trying to see if I can click on these things.
Please have a seat here in the witness stand.
Okay,
When you answer, please.
So they subpoena the main cop. They don't subpoena the other cop that gets that's calling for a rehearing. I need a completely new rehearing. Why do I need a new rehearing? The reason I'm going to need a new rehearing is because you only called one officer and I need another one. The one that actually illegally arrested me based on a coercion when there was no elements to be met there in the first place.
Morning. Please state your name.
Jack, appreciate you being here, bro. Hopefully you ain't gone yet and you just posted that. You be blessed as well. We love you, my brother. Thank you for coming in. I'm glad to see you here, Jack. We'll see you next time.
Please state your name for the record.
Officer Marcos Cardoso. Marcos Cardoso.
Officer Marcos Cardoso, are you currently employed?
I am.
What do you do for a living?
I'm a police officer with the Miami Beach Police Department.
Could you describe your training and experience?
Right now I'm a uniform patrol.
Okay, so they start doing all the, early stuff on. Let's see if I can come down here and make it work.
So it took some time. I was on the passenger. Initially, I was on the passenger side. Officer Hot Drive was on the driver's side, knocking on windows, flashing on lights. 2-3 minutes into it, the defendant, he woke up, kind of looked confused, and turned on the car, and then went back to sleep or unresponsive.
And what did you observe about his demeanor?
I mean, he looked confused. He was pale, flushed. He looked a little bit like he may have been under the influence of alcohol or any narcotics or drugs.
Were there any keys in the vehicle?
At the time with me.
Okay, really? Or was he just fucking waking up, bro? Maybe he was in a deep sleep.
Did they say he looked pale?
Yeah, they said this black nigga look pale.
He's a dark black man too.
I'm telling you.
What the fuck?
Something to consider. Just because they saw the open containers and because he was sitting behind the wheel, that may, I'm not saying for certain, but that may have given them the angle that they needed to prosecute. Had he been sitting, what I'm saying is, had he been sitting in the back seat or something with the keys, I don't know if the keys were in the ignition or not. I'm not saying that I agree with it, but I'm just saying that might have been the reason why they got the angle.
They're trying to use that angle. They're trying to use that angle, but you got to remember, this is a public parking lot.
No, it doesn't matter where he is. All I'm saying is just because somebody was sitting behind the wheel, if that seat were empty, if that seat were vacant, then they basically
Papa Bear, Papa Bear, listen, Papa Bear. He was in a private parking lot.
Oh, copy. Okay.
He wasn't
All
in,
right.
he wasn't
All
in
right.
no
All right. All
public
right.
area. He was in a
All
private
right.
park.
All right.
That's
That's true. All
that's
right.
essentially
All
like
right. All right. All right.
that's essentially like I'm in my driveway.
Yeah. I'm tracking.
Okay.
They have to show cause for their actions.
Okay. Hold on.
Me being outside, I couldn't see it, but there must have been
That's
because
why
he
they
turned on
love
the car.
traffic stuff.
Was the vehicle on or off?
When we first made contact with the vehicle, it was off. After 2 minutes tapping on the window, he turned on.
And were you able to speak with the defendant?
I believe only after he lowered his driver's side window a little bit. That was when I walked over to the driver's side.
And what did you notice when you walked over to the driver's side?
Well, again, signs of impairment. I asked him if he was having some sort of medical episode. He was not responsive at all to any of my questions. I then asked him if there was because I noticed from the outside of the vehicle through like a little opening that they have between the passenger and driver's side, I noticed a clear like glass bottle, and it was clear that it was an alcohol bottle. So I told him it was open. It had a little bit of residue in it. I said, "Have you drank? Are you intoxicated?" Didn't answer any of my questions.
And officer, when did you first notice this bottle of alcohol?
It was while speaking with him from the outside of the car.
From the outside of the car?
Yeah.
And you noticed that you mentioned that you noticed signs of impairment. What signs of impairment did you?
What'd you say? Go ahead.
Don't we object at this time for a call to draw a conclusion? He cannot tell that that was alcohol. He said he saw residue. Where exactly did he see the
no,
residue?
no, I'm not gonna object. Let them testify at this point. I'm gonna come through too, right? I'm gonna come through too.
Okay, so Officer Cardoso's BWC will be coming in as evidence without objection for the defense as exhibit, Madam Clerk.
State's Exhibit 1A will be introduced as State's Exhibit 1.
Thank you. While the state prepares the BWC, let me take a minute from Mr. Robin Francois' case. I see here Mr. Dorsey. Thank you. Let's go.
I don't know about what they moving on to another one, but okay.
Police, open the door. Police. Open your door. Police, open your door. Open the fucking door. Open the door. Open the door, bro.
And you can hear them, bro. Like they're just so crazy with it. All right, so let's see.
Officer, when did you notice the gun in the vehicle?
The gun?
Yes.
It was once we opened the door.
And at that time, was open carry legal?
No.
And what other signs of impairment did you notice when the window was rolled down?
Again, like I stated, there was a lot of confusion. A lot of he took long to answer a lot of the questions, and a lot of the questions he was just unresponsive. He was ignoring us.
And where was the gun?
It was on the floor in between the seat and the door jab.
Okay. I have to come over here because again, we're looking up open carry in Florida. Okay, if that's what we got going on. We're looking up open carry in Florida, and what we look
You can
about
open carry while fishing, hunting, or camping, and it looked to me like he was camping right there.
I mean, bro. First off, that ain't even the
There,
base of it all.
there's a Florida statute. I forget what it is, like 495 or something, that says you can open carry while hunting, fishing, or camping.
Listen, that ain't even the basis of it. Look at the basis of it. Adults legally possess firearms can open carry them in public. Where is he at?
He's in public.
No, he's not.
In private?
He's in private. He's on a private parking lot that he paid for. That is not open to the public.
Well, I watched a deal on somebody going through that same thing in court. They were at a gas station that was open 24/7. I forget what gas station it was, but it was a privately owned gas station. But because they're generally open to the public, that makes them a public place.
Okay. I'm still going to combat that because that's private property.
That's what I'm saying.
That's private property, bro. So, unless there is a complainant, there has to be, again, reasonable articulable suspicion for one to even engage with you. right? If there's no reasonable articulable suspicion of any crime being engaged whatsoever, then how are you even going to try to speak with me?
Wasn't that the attendant
Involved?
that did that though?
Go ahead,
The
brother.
attendant that wasn't that the attendant that initiated the whole welfare check? So I mean, it's not like they submitted an affidavit, but I mean, technically, he's the one that initiated it. Isn't that not true? Or
Who initiated it?
the parking attendant?
Oh, yeah. So the parking attendant did initiate it. Yeah, there's some form, but then again, you got to remember it even gets deeper. Now we're going into another layer. Then it's great that you mentioned this. So when coming across a security guard, you got to remember, or that we've spoken of with Robin, is that when entering into this private parking lot that you paid for, was there any notice given that there is no sleeping allowed in the parking lot?
Relax. Relax.
Okay. If we're getting into the depths of it, if there's no notification whatsoever that sleeping is not allowed in this private parking lot, therefore moving into the aspects of there's no notice. Right? So what was the complaint being established about when it comes to the parking attendant sleeping in the car? But yet you ain't giving me no notice. Right? So then you just come around and you're like, oh, well, you can't be here. Well, at that point, because there's no notice and you haven't provided me with any kind of policy that shows that notice that I can't sleep here, that's a violation. You see what I'm saying? So that's how I would go about it, because there's kind of a process here of the initiation of why you're fucking with me when I've paid to do whatever I essentially want in this private parking lot, because you haven't given me notice that I can't do such as long as I'm in my car.
Also, on that open carry, you can't open carry in your house. You're in your house,
right?
So if that gun was in his car, it's the same thing as being in his house.
That's why I say it'd be the same thing as sitting in his driveway.
Yeah.
The armed fisherman in Florida, he fights this all the time. Open carry, going fishing.
The armed fisherman.
Yeah, he just come out of a trial that he won because a mayor or something said that he was stalking her. But yeah, the armed fisherman, he knows those statutes and codes very good in Florida.
What that mean?
I have a
But
question.
Don't even the open carry laws go against the Second Amendment? Aren't they repugnant anyways?
Can I respond to that?
Yeah, go ahead.
Is it true that there's a difference between a firearm and an arm, a private arm? Is there a difference between?
If you
There's a huge difference.
Right. So the private arm that's constitutionally protected. The firearm is a creation of the federal government, right? It's part of the
or the U.S. citizen. Yeah,
right.
That would be one way of putting it.
Right.
But
so if he had his own arm, a private arm that he bought at a private gun show, then that would not be subject to any of the current gun laws that we're going over right now, correct?
Well, see, that's the thing. So the definition of the word arms would include their definition of the word firearm. Firearm would not include, but they try as much as they can, right, to get around the Second Amendment. But it's a lot easier to, the Florida statute about why you're hunting, fishing, and camping. Okay. The Second Amendment is the most important. So this is why I think 100% that the castle doctrine and the right to defend yourself is the most important right that there could be. Because without that, none of the other shit even matters or could even be possible. So, and back to the fruit of the poisonous tree, when they open the door beyond the welfare check, ultimately what it is it's a false report from the security guard that led to the false arrest. So it all starts with the security guard, but then once they showed up, did their little welfare check. See, the Castle Rock versus Gonzalez, bro. There is no legal duty. Right now in court, they're sounding like there's a legal duty to follow up. It would actually be with the security guard. And see, this is why there's no investigation. See, they didn't even talk to the security guard, right? They went right for the car. See, right into the action. They're just like when they killed George Floyd, they didn't go and talk to the people at the store and confirm whether the bill was fake or not. No, they just went right to him and did what they did to him. Zero investigation, zero due diligence, just right into whatever we want, right?
So what would you what crimes would you accuse the officers of doing in that case? Would that be like conspiracy? Would that be like peonage?
Yeah,
dereliction of duty, failure to intervene, that failure to do literally anything that they're supposed to do.
Look at the procedure they're held to. They never followed their procedure
at all, from what I'm seeing.
And then,
right,
and all that that's misconduct, and that leads to false arrests.
Right.
Which is why I got arrested when I was standing there at the courthouse, when the people that worked there for no reason called 911, and more of them showed up. And of course, they're stupid, so they just arrest me for assault, resist, obstruct. Right? All of that shit is misconduct. That's false declaration of an emergency. So it's the same thing. If that guy paid to be in that parking garage, and like Cam said, so that's private. See, in that little slim distinction, public and private. Yep. But regardless, even if it was a public parking lot, there's no legal duty or obligation to protect. So even with the excuse of the welfare check, that's an invalid excuse anyway. They use it all the time. But see, it's just the one huge problem we have in this country is false reporters, right? To see something, say something, right? So false reporters never get prosecuted, ever.
Are they supposed to get prosecuted?
That's great.
Yeah, if they show up and do something stupid, right? The false reporter never gets charged, ever. I mean, I don't know how many false reports it would take to actually get charged for that, but I've never seen anybody who false reported,
A couple of days ago, I looked up the KRS statute, Kentucky Revised Statute. I just put KRS warrantless arrests. And
this is why it's so disgusting, man, because people will kill you. They'll fucking kill you. And all kinds of horrible shit happens because people just talk. And then once they get the police involved, using police, I've noticed most cowards will use the police to, once you get them involved, then that protects the coward, because they're all cowards. You understand? It's disgusting. And it's one of the most.
It is. You're right.
One of the most messed up things in this country, man.
It is, bro. And you can see it. That's why it's like, what ends up happening here is that I think the security officer came and told Robin, hey, y'all need to wake up. There ain't no sleeping in this bad boy. And Robin's like, yo, leave us alone, bro. Like, we paid. We can sleep here. Like, we're not ready to leave. It's not safe for us to leave right now. Just let us sleep, bro. And dude's like, fuck that. I'm calling the police. Calls the police, and then they come out here and harass them, right? And that's the whole point. It's like, we didn't need you to harass us. We would have woken up in probably 5 to 6 hours because we paid for it, whether the car was sitting here or we're in here silently sleeping. And then we would have left when we were okay to leave. Instead, what they've done is created this whole thing of a monetary scheme where you're sitting here being harmed, right? Your time is being taken up, bro. Like, you got irreparable harm that's being upon you at this point. That is a lawsuit. It is a violation of your life, liberty, and the pursuit of your happiness because you're having to deal with something you shouldn't have to deal with because of the agency's arms of harassment and coercion in the first place.
It was on the floor in between the seat and the door down.
It's literally to convert otherwise not traffic stop to a quote unquote traffic stop. That's
yeah.
Officer, is it fair
what
to
it
say
is.
that you don't have to take one for traffic stop?
Correct.
Okay. Because it was interesting to note that on your direct examination, you said 2 to 3 minutes unresponsive. Okay.
That's a lie. Again, that's a lie. 2 to 3 minutes unresponsive.
Okay. All right. So let me go back.
Of course.
So they're going to go through that a little bit more. Let's see.
So I'm going to pause it here. You said on direct that he was unresponsive. Mr. Francois was unresponsive for 2 to 3 minutes, correct?
Correct.
You stand by that statement, correct?
I mean, he's been unresponsive for a lot more than 2 to 3 minutes.
Okay, so you're standing by the statement that upon approach, it took him 2 to 3 minutes to respond to you, correct?
I mean, that was an estimate. Now that looking at BWC, it could have been 30 seconds, 40 seconds, a minute.
Okay, so are you retracting what you said on direct, that it wasn't 2 to 3 minutes unresponsive, right?
Yeah.
Okay. All right.
Okay.
So
right there we got perjury. Right there we got perjury. He just retracted the statement. That's perjury number 1.
That on your body camera, it says on the top 04/18/09. Is that a fair assessment of when you first approached the car?
Correct.
Okay. Now let's see for himself. We don't have to go by your word. Let's watch the body camera and see when he quote unquote is responsive, okay? Sure. I gave it a little bit, I read it a little bit, but would you say, is it fair to say 04, 18, 30, 36, 40, somewhere around that range is when he responded?
That was the time that he appeared to be woken up.
Okay, and he's looking at you, correct?
Not really.
Okay,
No.
he doesn't look at you and then look at the other officer?
He looks confused.
Okay.
I would have asked the counsel, being counsel, I would have asked, and why do you think he would have looked confused? I would have let him answer, and then I would have asked, could it possibly be that he had just been woken up by the police pretty aggressively? I mean, how would you feel if someone was, I'd let him answer, and I'd say, and how would you feel if you were woken up with someone just cussing at you like that?
So does he look towards your direction? Yes or no?
Towards my direction.
Okay,
Correct.
does he look at your other partner's direction on the driver's side, correct?
Yeah.
Okay, so would you say about 20 seconds to when he, Mr. Francois, looks in your direction and looks in your officer's direction?
Approximately.
Okay. And obviously you've never met Mr. Francois before, correct?
Never.
You don't know what he normally presents as?
Never.
Okay, so because you indicated that he had a flushed face and you're looking at his demeanor while the window is closed, correct?
I mean, yes, and then once I also approached his side.
Right, but so you're making observations about someone, whether they're impaired or not, based on you just walking up to them for 20 seconds. Is that correct?
Correct.
Okay.
As counsel, if he would have said correct like that, and I would have asked him, and what medical degree do you have, or any kind of medical trades or certificates do you have to establish that truth, or is that just an observation, right? I mean, I'm going into every question, for me at least, is I'm trying to discredit this nigga in every form and fashion.
And at that point, at 04-18-36, you don't see obviously the open the bottle of alcohol, correct? You don't see it at this point.
I only see it from his side.
Right.
From
So,
the driver's side.
like I said, my question is, from the timestamp we have now on your body camera, you don't see the bottle.
That is correct.
Okay. And the officers, let's play the video.
Police, open door.
To be honest with you, this private attorney ain't do that bad, right?
Police.
He could have been a little bit more aggressive, but it would be bad, I guess.
Open your door. Police, open your door.
So at this point, you're yelling, you and the fellow officers are demanding that you open the door, correct?
That is correct.
That is not a request, that is not asking for consent. You are ordering him to open the door, correct?
Correct.
Okay, so if you're ordering him to open the door, what do we have then? Is that not fruit of the poisonous tree? Because you can't order him out. Why can't, okay, I'm gonna ask, y'all give me some case law. Why can't he order this guy, Robin, out of the car? Give me a case law that supports that. Why can't he?
Because they have no probable cause.
Okay, yes, case. I want some case opinion. Come on, y'all, give me some case opinion. Where is it at? What does it state?
Pennsylvania versus Mims.
Okay, got Pennsylvania versus Mims. Why can't he ask him out? Give me another one.
Because he's not being dangerous.
He's not dangerous, bro. There's no safety risk being posed to that officer whatsoever. It's coming out along, bro. They know this.
I think there's two elements to that P versus Mims, as well as the being dangerous. I think one of them has to be like a physical threat, like they can see some type of weapon. And if you can dispel that alarm, the other one is you yourself being a physical threat to them as you were going to attack them with your bare hands or something.
Saying it so perfectly. Thank you, Kane. Look, we got on 3/25/25 last year, okay? This order was filed in the Charleston Division of Federal Court by Judge Thomas E. Johnston. All right, over there in the where are we at? I forget. West Virginia. All right, we're in the Charleston Division. Okay, and this is his order. This is what the judges write in relation to a response from a civil fucking lawsuit that is occurring or has occurred in the past. So it's pretty recent, y'all. We can see what the judges think. What do they think? While it is true that an officer may order a suspect out of the vehicle or out of the car during a valid Terry stop. What is a valid Terry stop, y'all?
Something with probable cause that starts with articulable suspicion.
Of what?
Of
crime.
A crime. Everybody say it. A crime.
A crime.
Crime.
Which is injury to another.
Loss,
Such
injury,
order
harm.
is only valid
Or
if
a
an
debt.
officer. Oh, sorry. Go ahead.
You're good. Loss, injury, harm, or a debt.
Yep. Such order is only valid. What order? The order to get out of the car. Okay. Such order is only valid if an officer, quote, from the case law, this is what the judge is saying, possesses an articulable and objectively reasonable belief that the suspect is potentially dangerous, unquote. Long 43 U.S. at 1051. That's your reference point right there. They can't order you out of the car unless they have some kind of articulable and objectively reasonable belief that I am dangerous to you. Period. Period. So, in this situation, as far as the federal court is concerned, those troopers, those cops, would cite nothing to suggest that between initiating the traffic stop, if it was a legal traffic stop or not, and the plaintiff's laughter that occurred, that triggered the officer, that these deputies, this one was named Ellison, noticed anything that would suggest that the encounter became dangerous to them. And without such justification, the act of ordering the plaintiff out of the car is arguably unjustified. Ding, 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 ding. Winner. Winner. We winning. We're winning. You understand what your rights are, bro? What your liberties are, bro? They can't just order you out of the car. Sorry. It's already been dictated, broski.
But this is my town.
No, it ain't your town, Richfield, Duran. We're coming for that ass.
Point, you believe you have the legal authority to order someone out of their car, correct?
Correct.
Even though you had come there, the only basis for you coming there was to check on their welfare, correct?
Correct.
That was why you were there, right?
I mean, it's the same thing with Washington State Patrol, is it not? It was a welfare check. That's what he said. Then they want to go point at my license plate and say, oh, you got license plate coverage. You're not supposed to have that in Washington. Do you see the Oregon plates, bro? How am I supposed to know we ain't supposed to have? And I'm parked. You can't fuck with me.
Correct.
He's alive, right? He's alive, right?
He's alive. The other person's still in
Okay, but I'll get to the other person. He's alive. Mr. Francois is alive, correct?
Yes.
He's responding to you, correct?
Yes.
Okay.
Open the fucking door. Open the door.
So there's somebody that says, open the fucking door. Who's that?
That was me.
Good, okay.
Good, okay.
So that was you letting him know that you're not messing around, right? Like this is an order to open the fucking door, correct?
Correct.
You see what I'm saying? The private attorney's doing all right. He's setting the tone for suppression. Okay, this I don't know what's going on with the judge here, but I need factual findings in the conclusion of law. I need an order that establishes how this. Look, here they go talking to the what's it called too right there.
That he had no choice but to comply, right?
As previously stated 12 to 14 times.
Right, okay. And you were telling him to open the fucking door based on you walking up and him waking up and not immediately opening the door.
Based on there's still a passenger unresponsive.
Okay. So you made that comment. Are you representing to the court that the only reason why you're telling him to open the door at this point is because you're concerned about the passenger?
Well, we initially were sent there for a medical emergency,
Right.
2 unresponsive males.
Right.
He got some sort of consciousness where he appeared to be woken up, unresponsive to any of our questions. He looked confused, as many patients that are going through a medical episode sometimes wake up and look confused. That was when I continued to ask him open the door to us assess what was going on.
Okay, you keep saying confused because let me go back. So we're on 04/1938 for the record. Let's go back because I could have sworn, you could correct me if you have an opportunity to watch it again.
Of course.
I could have sworn Mr. Francois responded to either you or your fellow officer about why he doesn't need to open the door. But let me see, because you keep saying unresponsive, so I want to make sure we don't just take your word, we just watch the video.
Is that where you state that he spoke with us? I'm sorry, is that where you stated that he spoke with us?
No.
No.
Open the fucking door! Open the door! So right before you say open the fucking door, he's talking to your partner on the other side, correct?
Okay, yes.
Right?
Correct.
Okay. And his response to you saying to open the door was to turn on his car, correct? In order for him to roll the windows down?
Correct.
Okay. No, I'm just making sure because you keep saying he was unresponsive.
Saturday.
That wasn't my instructions to him, though. My instructions to him was to open the door. So I don't know why he would turn on the car.
To have a conversation with you, no?
Sure.
Look at the cases that came up that week. Like this cat just got ordered out of his car because he nodded off in his.
At this point, that was your hand that reached into the window, right?
I have not reached into the window.
Okay. So whose hand was this?
Nodded off before he was off to do whatever he was going to do. There's no crime in that.
Right. At this point, it is to be noted.
No question pending.
Okay.
Okay, so let me see. Getting down, no warrant. See, he gets into the private attorney actually gets into everything. He actually goes into he asks him, do you have a warrant? And the reason I think this is really important as well, and why we should get Robin should have a written determination that comes from the judge for sure, dude. And I know she mentioned at the end that she could provide it and it'd be worded different, but they really need that because that's going to work out really great for the appellate court because it's going to set an alignment for reconsideration and then a rehearing, to be honest with you. And the reason it's going to come to that is because she's not going to be able to articulate. She made a denial, right? But she's not going to be able to articulate very well how she didn't come to the conclusion that what they did after opening the door was completely illegal. And to combat that on our side is very easy. I don't see that as hard at all. I think most of us know that we could combat that with great ease. That they just can't intrude on you after a welfare check to then establish, like crimes against you. Like that's very weird. I saw someone had their hand up, but I didn't quite see who. I think it was you, Aaron. Would you guys just say, yeah, what's good?
What is a written determination?
So the judge is like, that's an order, right? So, isn't that what it is? It's an order, right, Kane? We looking for that order.
A written determination, yeah, it's what you'll get back. It's an answer from the judge, basically.
Yeah, that's what you, and that's owed to you as well.
So in this case, as this attorney is doing, he's doing fairly well for he's kind of interrogating the officer. What is he supposed to do now? What motion should he then file?
Well, there's a lot of different routes anyone can ever take. I mean, not to say should happen or will happen, but there's just so many different things you can do. You're like, dude could, the defendant could do a sworn motion to compel written findings of facts and conclusions of law, which is pursuant to the Rules of Criminal Procedure 3.190G and due process clauses of the Florida, in the United States Constitutions. And the reason is that you're coming in pretty heavily mentioning what you need, the mandatory nature of the rule in and of itself, as far as when you invoke it and when you mention it, what you're supposed to be given. All right, but you got to invoke it. That's the whole point of the knowledge, right? You got to have the knowledge of knowing what you can invoke to then receive that. And it's pretty cool that, once you mention it, and it's a deprivation of due process and appellate rights are concerned, the courts really put on notice that, you're putting us in a tight spot. We do kind of owe it to them, to make sure that all of this actually happens. It's crazy, bro. But going back to the point of did you have a warrant, yes or no, really makes it clear that this attorney is paying attention and putting forth some elements that can be brought forth. Because, again, we get into the depths of an arrest without a warrant. Not in Washington. I need this in Florida, homie. Give me the Florida statute. So the Florida statutes in Florida, when arrested by an officer without a warrant is lawful. Okay, so a warrantless arrest is normally what is termed in other states as far as the statute is concerned. But that the person has committed a felony or misdemeanor or violated a municipal or county ordinance in the presence of the officer. An arrest of the commission of the misdemeanor in violation of a municipal or county ordinance shall be made immediately or in fresh pursuit thereof. Okay, now check this out. We got to look at the context of the actual statute. A felony has been committed, and he or she is reasonably believes that a person committed it. That's weird. Why would right in the second one you'd go with the context of a felony being given? Like that's kind of egregious. I think that's a little bit. I think that it's felonies are a lot more serious. Yeah, so like it's pretty serious. And then he or she reasonably believes that a felony has been committed. Okay, a warrant for arrest has been issued. We don't have a warrant. A violation of Chapter 36 has been committed in the presence of the officer. Such an offense may be made immediately or in fresh pursuit. Right. Seems like it's about a driver, so one who is literally in operation, and then in commerce as secondary as well. There's probable cause that one is committing a criminal act. No. There's probable cause to believe the person has committed an act of domestic violence. So you can see it's more about the crime elements here being made, right? Throughout this whole statute. And Homeboy is not doing that. He's literally minding his own business, bro, sleeping in a car, which is a natural act. Like, I understand that, like, you need to like, you're wanting to intrude in my life as far as the things that I naturally have to do, which is sleep. I'm sorry, I have to sleep. But if you could allow me just to sleep in my own peace, wherever that may be in this life, I would really appreciate it. Because if not, that's a violation of my life, liberty, and the pursuit of happiness, because everyone has to sleep.
Do you know if Robin got the 911 call that guy made?
Oh, yeah, we just went through that. So, Robin, are you still or what?
I'd be curious because why would they send men with guns instead of men with band-aids to a medical call?
Robin, are you still in here?
Yeah, I'm here. The 911 call was they never preserved it.
That's what I figured.
Mm-hmm.
Why would they send men with guns instead of men with band-aids to a medical call?
Okay.
That was never a medical call, probably distributed to the police officers.
Exactly.
A welfare call, yeah, right.
So there's no what you call it? There's no 911 calls at all that they're getting, right? So that's an issue. Man, like, how did y'all get out here? It's pretty wild. All right.
No warrant.
Okay.
No warrant.
So again, at 01952, right? The passenger is clearly awake, has his hands up, right? Looking at your colleague, your partner, correct? And your partner is telling a private citizen to get out the car, correct?
Correct.
Okay. At this point, do you have?
It's cool because in the questioning and now in the record, it says, at least the attorney did it. And your partner's telling a private citizen to get out of the car, correct? See how this lawyer's actually doing okay, right? But to me, he just focuses on one situation rather than multiple, and making sure that the other officer that got coerced into the false FSTs is also included as well. Bringing, I guess, all of it in, as far as the evidentiary and motion and limine, so that way you can exclude a lot and or suppression motion. I think it should be a little bit bigger, but hey, whatever.
Is clearly awake, has his hands up, right? Looking at your colleague, your partner, correct? And your partner is telling a private citizen to get out the car, correct?
Correct.
Okay. At this point, do you have any authority to arrest him?
Arrest conclusion calls for legal conclusion.
Sustained. Do you have any basis to get him out of the car?
Yes.
Okay, what's that?
We're still in a medical call.
Okay, even though he's awake, he's looking at the officer, having his hands up, you still believe that there's a medical emergency that entitles you to pull him out of the car?
Correct. There is no firefighter or cop that will respond to a medical call and not make contact with an individual by just talking to them.
Okay, so your understanding of making contact, of doing the welfare check, right? Because you're coming there not as someone where you're coming to them as a suspect of a crime, correct?
Correct.
Your disposition when you get there is to make sure that they're okay, right? Right?
Correct.
Okay, and your idea of making sure they're okay is to yell at them, say, get the fuck out the car, and open the door forcefully and tell them to get out? Well, that's your idea of welfare check?
Counsel, we need to leave the foul language out of the questioning, please.
Look, the judge don't like it. The judge don't like it. But it's perfect. The private attorney said, get the fuck out. You think that's a welfare check?
I understand there was foul language in the BWC. You've said it enough times for the court to know that there was foul language used. Let's move on from the F word, please.
So your understanding is that you still continue your welfare check?
Correct.
Okay. And that's when you stick your hand out at 0, 19, 56, 55, and you open the door to
Correct.
Mr. Francois' driver's side, correct?
Yes.
And you tell him to get out the car?
Yes.
Question asked and answered.
Overruled. It was already answered.
Did you hear the passenger officer say, what are you guys doing here? Did you hear that? Okay. You want me to replay it?
Sure.
Okay. And at that point, you're still at 0:19:59, even though the passenger says to your colleague, what are you guys doing here? He's clearly looking at your colleague. You're still conducting a welfare check, correct?
My colleague said that to the passenger.
Okay, so your colleague said that, not
My colleague said, what are you guys doing here? To the
Okay,
passenger.
and does he gesture or make any kind of response?
He did this.
Okay.
As in,
So at this point, at 0:19:59, when the doors are open and you're still ordering them out of the car, you're still conducting a welfare check.
no. So at that time, once I approached.
Oh, so no, you're not conducting a welfare check anymore. There it is. That's established.
Oh.
That's established. Okay. So he said no to that answer and gave a timestamp. Okay. That should be the point of suppression. That's the moment right there. Fruit of the poisonous tree. Why? Why? Well, because he admitted to it. Okay. That's number one. You could go a little bit earlier, but that's a good point to start. That was his own sworn statements on the record. So that should be the point of the fruit of the poisonous tree where we get the suppression at. Okay. Because he's gone from welfare check to now criminal investigation due to the fact of what Robin has privately, okay, in the back of his car in a private parking lot. It is no concern of the officers that he had a bottle of alcohol in the back of that car. None, bro. It's of no concern, bro. Why? Because Robin is not operating his vehicle. There's no operation. There's no movement. And he's on private property. And there's no notice that homie cannot sleep in his car. There's no notice coming into this private parking lot. No notice was given on the ticket. It's not plastered anywhere. Therefore, it's not illegal to go to sleep in this parking lot if one seeks to do so. So the interaction of a false, misleading welfare check, whether you figured out whether he was good or not, and then you sitting here saying, okay, it's no longer a welfare check, so we turn it into a criminal. Why? You have no reasonable articulable suspicion to do such.
What is the original case that they didn't allow in?
Say that one more time.
There was a case that was on point that the judge didn't allow in. What is it? It probably has ruling or rules on this or has precedent.
Yeah,
and
there is
we know
precedent.
what it is, then we can probably just forget the fluff and just go right to it.
Well, then let me see if I mean I don't want to go straight to the fluff. I want to let people hear how the private attorneys are at least arguing in these evidentiary hearings. You know.
Yeah, we should work through
I
the
got no
whole
bias
logic
on
to it. I agree.
Okay.
Time once I approached the driver's side door, like I said, I was clearly already in vision of that alcohol bottle.
Okay.
So although yes, we were telling him to get out of the car because we still had a job to do to make sure they were okay and not having a medical emergency, I knew that I had all the right to take him out of the car due to him illegally having an open container inside the vehicle.
Okay.
Okay, that was if he's driving, maybe possibly, but you got to think about it like this, y'all. What if I had me like a Patron bottle in the back of my seat, and and other things like a cake, and party supplies, and I'm going to go visit my friends to have a couple drinks at a party that we're having because someone just turned whatever age they turned. Is that illegal for me to have?
I believe UCC 1-909 or 901 explicitly that's private automobile.
It's private automobile. Household goods.
Same as household goods, same as your house.
Yep. Household goods. Yep. UCC 1-109. Okay.
Yep.
So when you're coming into it, like I got that into my back seat. I'm not drinking it, but I am taking it, and that's my own private property, bro. Like I can
Who cares if it's open?
Yeah, who cares if it's open or been open or not? It's been open at the house. What you want me to do?
Mm-hmm.
Not actively. It's crazy to me, bro.
Okay. And you believe that the open container that you said you saw previously before you ordered him out of the car, you believe it had alcohol in it?
It had residue.
Okay. You were able to see that from the door, from the door being closed, right? From the outside, in the back seat, you were able to observe that an alcohol bottle had some alcohol in it.
Yeah, it was not hidden.
Okay.
And follow-up question, and you believe the owner of that bottle to be Robbins? Like, you have no clue about how long that bottle had been sitting in the back of the car, had you? Like, man, are you aware of the actual contents? And then even actual bringing a charge against him, do you have the bottle here today as evidence? Where's the bottle? Did it have alcohol in it? They made an arrest? Where's the bottle?
Well, such a good point, bro.
And
That's
obviously, you had no proof that Mr. Francois, that was his bottle, right? Because he's in the car with another passenger, correct?
Correct.
Okay. So, but even though you had no proof of that, you had no idea of that, you still felt you had the ability to order him out the car.
Correct, based on his actions.
All right. And so you were ordering him out the car prior to observing the alcohol, though, right? Would you agree with that?
For the medical emergency, that's correct.
Okay. So during the time that you were ordering him out of the car for what you say medical emergency, at that point, when you go to the driver's side is when you now switch and say, well, now this is not a medical emergency, this is a criminal investigation. Is that what you're saying?
No, like I stated, although I knew I had all the right to remove him out of the vehicle and arrest him, I still had a job to do, was to make sure that they were both okay. So if you want to put it this way, I was playing two rules at once. Yes, he was committing a crime where he had an open container. He appeared to be having a flushed face. He was confused, showing all signs of impairment. Yet I still wanted to make sure that he was okay and the passenger was okay.
Okay, so you believe that you had probable cause to arrest him for open container?
For open container, no. Like I said, for him being under the influence of alcohol and behind.
Oh, one thing I did want to show Aaron real quick though is that if you're getting into written determination, right? When you submit something and the judge just makes an oral denial or something like that. Oh, I deny it, right? Well, you're entitled a written order, okay, for them to give you factual findings and conclusions at law, right? It was the same thing that we went over when we went into Hayden's Discord, when we saw that the judge gave out all of her factual findings in an order based on the conclusion of that motion to dismiss, which she took as a motion to suppress after going through evidentiary hearings. So, like Robin's going through these evidentiary hearings right now, she denied the motion to suppress. Essentially, it's the most craziest situation ever, bro. But like, she's so on the record, she's so messed up. So it's so amazing. I don't, dude, it's crazy.
It was to make sure that they were both okay. So we took it. We were.
You're owed. What we do is we bring forth a motion to require the written determination on prior motion to dismiss, and we bring it forth and say what we need, and they need to bring back forth an answer on why they denied it. And if they don't do that, then that's a violation of due process rights. And I guess I would just ask everybody, why would it be a violation of your due process rights if they don't give you an order?
What aren't they supposed to be transparent with why they're making these orders or why they're denying you of your rights?
Well, and I guess I would ask Rich if he's still around to see if because I know Rich gonna know this one. Why would it be a violation? What's the violation when they don't give you a written determination?
They're not showing good faith.
They're not going to show.
Confrontation clause.
It's 14th Amendment due process, but why is it due process?
You're unable to hold a defense.
Oh, is it because the judge is supposed to be like the referee?
You can't find the relief.
Bias?
Okay, yes. You have to understand why your theory and things that you have brought forth with everything that you comprehend is wrong. You have to understand more so in relation to like the theory. Like if I'm not understanding why I'm wrong and everything that I'm bringing, when I find it and can articulate it as being a violation unto me, why are you not giving me something with great depths that lets me understand where I'm wrong? It's a violation of my due process rights. I can't defend myself. Yeah, I can't defend myself properly if you not allow me to understand where I'm wrong at.
Mens res.
Nature and cause, I'm thinking.
Yeah, nature and cause.
Yeah.
In which relief
They
can be granted.
Yeah, they should be the grounds for everything.
I see.
Yeah, just want to let you know I'm back, brother.
Hey, brother. Yeah, we're just going through factual findings, but we're about to get to the more juicier part, I guess.
If you want to put it this way, I was playing two rules at once. Yes, he was committing a crime where he had an open container. He appeared to be having a flushed face. He was confused, showing all signs of impairment. Yet I still wanted to make sure that he was okay and the passenger was okay.
Okay, so you believe that you had probable cause to arrest him for open container?
For open container, no. Like I said, for him being under the influence of alcohol and behind the wheel and even turning on the car.
Oh, okay.
Dude asked him to roll down his windows. The only way for this car to actually roll down your windows is to turn on the car. Odd.
Okay, so you felt like you had probable cause to arrest him for DUI from about a minute and a half of interaction with him?
No, like I said, I had probable cause to remove him out of the vehicle because he showed signs of impairment, which after a field sobriety test and possible other exams, then he would be arrested for DUI. But it's...
So you were conducting...
But it's clear that y'all never even conducted SFTs. You just took him over to another spot, acted like you did FSTs, and then arrested him.
Other exams, then he would be arrested for DUI. But
hear me?
Yeah, we can hear you. What's up, Lynn? What's up, bro? Lynn? I heard him. I heard you
Can
one
you hear
time.
me now?
I heard you now. I heard you one time, Lynn. I don't know what happened, but you.
So you were conducting a DUI investigation. That's what you're saying. When you got to the door and you saw the bottle of alcohol, that triggered you to say, well, I can order him now out because of a DUI investigation.
Overruled.
No, like I said, I saw the open container. I already knew that was a him. Like I said, him with his actions and the way he was already being with us, it showed signs of impairment. Me seeing the open bottle added to that, where it also shows that his signs of impairment could be constituted because of that bottle being there. Open, had no cap on it, and it had a little bit of residue of alcohol. Plus, the way him and the passenger were both reacting, it appeared to be they were both under the signs of impairment or a medical emergency. I don't know.
I don't want to keep going over that because I just want to make sure to understand why. Because you essentially said that you were ordering him out the car before you made those observations because you needed to conduct a welfare check, right?
Correct.
Even though you're ordering him specifically out the car, even though he had already been responsive, rolled the window down, turned the car on, you all were still ordering him out of the car as well, correct?
Correct.
Okay. Even though at that point you still were conducting a welfare check.
That's correct.
Okay. So
I
your
don't know how to
belief
work
is
it that good. So
even though.
Hey, we hear you again.
Can you hear me now?
Yeah. What's up, Lynn? Why you keep coming in and out, bro?
I don't know what I'm doing.
Well, we can hear you now. What's up, bro?
I had email open. I guess it's working all right since I closed it. I don't know, man. I just got this little laptop, and I don't really know how to work it, dude. So,
Well, I tell you
bear
what,
with me, please.
it's okay. You're in this thing, and we're so happy to see you, bro. I'm glad to have you here, brother. You're finally speaking with us in this thing. What's up, bro? Got the laptop.
I don't never get no email no more, and I can't get on Discord. So,
You need to figure out how to get on Discord. You should make a new account since you got a laptop, boy. Yeah.
I got they want my phone number, and I don't use a regular phone number. I go through an app, so it kind of messes it up because it won't let me get the code. It says I gotta pay like $6.99 a week to get the code. So,
You should do Google Voice.
I'll figure it out sooner or later.
Yeah, do Google Voice. I'll put it in the chat for you.
Someone, if I'm in a car,
Yeah,
you come up to me because you have a right to
years
interact
old, man.
with me,
I don't
sure,
know how
okay.
to work.
And I show I'm okay, and I'm responding to you.
Stuff.
I'm
used to working
You still
with my
believe that
hands,
you could demand that person get out to make sure you're really okay?
He showed no signs that he was okay.
Okay, so you thought at that point, even when he rolled the window down, even when he turned the car on, in order to roll the window down and interact with the officers, you still thought he was going through a medical emergency?
Yeah, correct.
Okay.
Okay. Okay.
Okay, let's see where we're at.
Okay, so it's not a situation where you're dealing with someone that's the only person in the vehicle, driver's side.
Let's see.
4.
When did you notice the bottle?
When I approached the driver's side.
And when you're typically conducting a welfare check, what are you usually looking for to alleviate your concerns?
Well, it's just like any welfare check that we go to. We need to make contact with the patient. Make sure that although they're saying hello, it's not just hello. We have to ask a series of questions to make sure they're mentally there, they're physically there. Because although he woke up and he did this, and he looked at us, and he looked at our flashlights, he looked at lights, it does not just clearly say, oh, he's good to go, let me just walk out and leave. No, we needed other signs, as in like he was able to answer our questions. He's able to correctly, dispel that. Oh, okay, he is okay, and not okay, still going through some sort of medical emergency.
Bro, I'm sleeping in my car. Can you have common sense to know that I don't need no medical attention, bro? Like, what the hell y'all got going on? It's so crazy how someone's just gonna intrude in your life like this and then make a crime out of it, bro.
And were the responses you were getting from the defendant sufficient to make you think you no longer needed to investigate their welfare?
No, they appeared confused, even until we took them out of the car. They were
Yeah, they were confused because they don't understand why y'all are fucking with them. They was asleep. What you talking about? I'd be confused too. The hell y'all doing with me? Bro, I was asleep. I had just sleep. We've been traveling. We just got off the plane. We thought we would come over here to the beach real quick and just sit out on the beach for a couple hours and just talk about our lives. We've had a lot of shit happen in our lives most recently. And we just
He says patient. Did you catch that?
That attorney should have asked that officer, if you thought they were having a medical emergency, why did you make them get out and stand on their feet?
He didn't say criminal.
But wouldn't they have been better off as patients sitting down?
Like, for real, bro. Like, chill out. They have no...
They got no...
in this whole interaction, they have no... they're not trying to dispel anything. They're trying to create a crime. It's it's a whole bunch of arguing.
They're trying to create a situation for that young man.
Trespass us. Only thing you can do is ask us to leave. So ask us to leave. Anything outside of that, you're violating our constitutional rights.
Okay. Let me know when you're done talking. Is this shit recording?
Yeah, it's recording.
Now, did you ask us to leave? We get to know. Stop talking to him.
Did you ask us to leave?
I'm telling you, when it comes down to it, it's really deep, bro. They didn't get out confused. They got out asserting their rights. I'm not gonna speak. And then when they started to argue the facts of what they knew, that's when the retaliation came, and the creation of a crime, and then the initiation of a rookie to make the arrest. Man, it's crazy. This is a conspiracy lawsuit for real.
To make sure that he was okay and to conduct that welfare check. And the reason why I wanted him to open the door specifically was it kind of got a little worse when he turned on the car.
And
I think I was there for a little longer.
This is crazy.
It got worse how?
Creating a false narrative.
It is a false narrative. Totally false narrative, bro. Oh, they did get the bottle, they said.
I want to talk about the bottle briefly. Officer, did you retrieve that bottle?
Yeah, we impounded it for evidence.
When you say you knew you could remove the defendant from the vehicle, was that when you saw the bottle?
Yeah, I mean, the bottle plus all the other signs. What? What's up? It says under the seat. What? Is there enough? The whiskey bottle right there in the back seat. Back seat. Next to the boat. That's that one. That's that one. Right next to the boat. There you go. Empty bottle over there.
Officer, was that bottle full?
No.
Did it appear to be alcohol?
Yes.
That's it. That's all the state got. So weak.
No further questions, Your Honor.
Yeah, no further questions.
You have one
So
right
weak.
across? Yes, Judge. Just...
Whiskey bottle right there in the back seat. Back seat.
When you said that you originally, when you were by the door, when Mr. Francois was on the driver's side, you said that you testified that you were able to determine, right, that there was still alcohol in that empty bottle from the backseat of the car with your position in the flashlight. That's your testimony?
Yes.
Okay. And you stand by that testimony?
Yes.
That you are able to see it clear, right? The alcohol bottle is clear, correct?
That's correct.
And it's a vodka, right?
No.
Okay.
Never
It's
said that.
tequila? It's a clear alcoholic substance.
It's a
correct?
clear alcohol bottle.
Okay, so you have a clear bottle, and then you have clear alcohol, right? And you're saying that you were able, from outside of the car, with your flashlight, able to determine...
See, I feel like Homeboy argued a lot of this when he could have put on a lot of different points.
And your colleague's the one that said there's still something in there, right? Is that a yes?
That's it.
And you didn't respond like, yeah, I saw it from initially. Have any other witnesses?
No, Your Honor.
The state rest at this time?
Yes.
Defense, do you have any witnesses?
Your Honor, in this case, the officers were conducting a welfare check. It took several minutes for the officers to conduct a welfare check and before they could actually get the defendant to speak with them. The officers couldn't just leave before confirming or dispelling whether or not the defendant was okay. In response to a welfare check, they can't simply leave or do anything else before they're aware of whether or not the defendant is okay. Both in that time and immediately following, they started noticing signs of impairment. They noticed the bottle. They noticed the defendant appeared confused, disoriented, flushed, signs of impairment. They also noticed the gun. In this case, within that time, the officers noticed that the gun was also not properly concealed. They noticed the bottle, the improperly concealed gun, and the defendant's multiple signs of impairment, including the odor of alcohol emanating from the vehicle when the defendant rolled the window down. So they asked him to step out. This was necessary. They were there to confirm that him and his passenger were okay. They couldn't do that from within, while the defendant and his passenger were within the vehicle. Again, because this was a welfare check, they could not leave before confirming that the defendant was okay. Your Honor, Florida courts have ruled already on investigatory detention in response to welfare checks. In the case of Daniels v. State, which I have here for Your Honor. In this case, the officers were called for a welfare check. Yes. And I don't get a copy, sir.
Would any of y'all go to the procedure that the police had to follow?
In Daniels v. State, the Second District held that an investigatory detention was permissible in response to a welfare check when it was ambiguous whether the driver was experiencing a medical emergency, under the influence, or asleep based on the totality of the circumstances and an objectively reasonable officer's standpoint. In Daniels, the situation was ambiguous due to the totality of the circumstances because the sleeping driver was parked at the exit to a parking lot, which is why a welfare check was called. The appellate court held that there were only 3 explanations.
Okay, wow, this whole case is that homeboy was asleep while parked at the exit. So he's blocking the exit for others to enter or exit, okay? It's a totally different situation here. Of course, but homeboy's parked perfectly in his own spot, clearly.
Which is why a welfare check was called. The appellate court held that there were only 3 explanations for the way he was parked: a medical emergency, being under the influence, or merely sleeping. The ambiguity gave the officers reasonable suspicion to conduct an investigatory detention even after the potential medical emergency had been dispelled. In fact, once it was dispelled, there was still reasonable suspicion because it made it more likely that the driver was under the influence rather than merely sleeping in the car parked in such a position. In this case, the case before the court today, the ambiguities present and the totality of the circumstances also gave the officers reasonable suspicion. They noticed his signs of impairment, that he was unresponsive to them for minutes. They noticed the bottle of alcohol. The officers observed that the defendant looks confused, and he even lies back down as they're trying to make contact with him for some time. They're not able to dispel their concerns about the medical issue before they start noticing the signs of impairment. They were faced with a similar situation as Daniels, and because this was a welfare check, they could not simply leave.
You hear that, bitch? Oh, excuse me. You hear this one? And they could not simply leave. They couldn't just simply leave him alone.
Look confused.
See, that's the whole Castle Rock versus Gonzalez right there, bro.
Couldn't leave, huh?
No duty or obligation to protect.
Yep.
So if there's no duty or obligation to protect, that means they can leave. They
Sir,
don't
are you okay? Yes, I am. Okay, we'll have a nice day.
No, they can't, Tony. They couldn't leave, Tony. They could not leave. They had to make sure that Robin was okay.
Yeah, okay.
That's what she says, Tony.
I know. That's all their thing with me, pulling me over to make it public safety because the state's the victim and all that jazz. If there's no duty or obligation to protect me, they don't have any duty or obligation to protect the public.
Man,
so,
the prosecutor says different, bro. They could not simply leave. Look at her. That's what she says in their closing argument. They could not simply leave, Tony. They couldn't leave.
The same video we're watching happened.
Right, and if you think about it, it makes perfect sense. They couldn't leave because they hadn't manufactured a crime yet. That takes time. A couple of minutes.
And for that aforementioned reasons, Your Honor, at this time the state asks that this honorable court deny the defendant's motion to suppress.
Now, one of the issues there was an issue that comes up. There's an issue that comes up with homeboy.
Oh my God, I was getting ready to say that.
Homeboy, hold on. there's an issue that is coming up in relation to the what you call it, which is the motion to suppress in and of itself. In the very beginning of this, they're arguing the motion to suppress, and one of the issues is that the defense counsel, the private counsel, was very vague in his motion to dismiss. So he was not very particular in relation to what he was asking to be suppressed, which in the very beginning was already given justification for the state to come through and say something in the very beginning, which is, yo, this dude's request for being suppressed is really vague. I don't know even what he's asking to be suppressed. He's just like blatantly putting something out there. And they had an argument in relation to that I didn't put on here, which is that the private counsel was all like, well, yeah, I guess I could amend it and change it up and add it. But it's like, why didn't you already have that added in the first place, homeboy? Like that's you know? So, yeah, continue on.
Counsel, any closing argument?
So, Judge, just to quickly address, like I said in opening, this case is essentially about the welfare check and where does it extend to. And the officer testified that he ordered the defendant Mr. Francois out of the vehicle initially because he wanted to conduct a welfare check. Prior to even him going to the driver's side, he was already ordering him out. I was using that language just to kind of show the authority and the way that they were approaching and asking my client to cooperate with them. It wasn't a request, it was a demand. The officer said so. At the point where Mr. Francois rolls his window down to perhaps meet them in the middle to have a conversation with them, they continue to order him to open the door, right? Even though, and the basis of that, what Officer Cardozo said, is that, well, the passenger still hasn't been checked on, right? So he's still like dealing with the other officer. That has nothing to do with Mr. Francois. At that point, you're there to conduct a welfare check. So the basis the state is going forward is that in order to do a welfare check, officers are allowed to demand and order forcefully open a private citizen's door, even though they're awake. They're having conversations. He had enough of the faculties, right, to recognize and to visually look at both officers, right? Pressed his ignition. He didn't miss it. He pressed the button to start the car. He immediately rolled his window down, and he was talking to the other officer at that point. And then that's when Officer Cardozo went and ordered him to his driver's door to open the door. And then he eventually stuck his hand in the car door and opened it just like his partner did. The gun was not found or not seized until after the illegal conduct of opening the door. The ordering them to open the door, that's the seizure at that point. So prior to the seizure, they had no basis to know that there was a gun there. So they cannot rely on that as that is a basis for the reasonable suspicion of why they're doing an investigation at that point. So all we have at this point, right, once he gets to Mr. Francois' driver's side is, okay, he's awake now. Allegedly, I see, even if you believe him, let's say you believe what he said is that he was able to see the alcohol bottle in the backseat, right, of the vehicle, and that he was able to see that there was a little bit of alcohol in there. The court saw the video. It's a clear alcohol bottle. The alcohol is clear, right? But let's say you believe that, right? At that point, he cannot attribute that to Mr. Francois, right? He doesn't know. He said, this is not a situation. It would be totally different. I would even submit, I don't know if I may have a good faith basis, if Mr. Francois was alone in his vehicle and there was a bottle of alcohol there and then they smelled the odor of alcohol, right? At that point, I could say, okay, maybe, right? But you have another individual there, and if you're saying, and he said he's still conducting a welfare check, you're not, even what he said where he was like, I'm still concerned about him, those are questions he was like, I want to talk to him. There's no basis to have him get out of the car to have a conversation. He even said it himself. So he wanted him out the car from the get-go, regardless of whether his welfare, he was okay or not. He was ordering him out the car, even though he was already talking to his colleague. That's how you know that the welfare check is not the basis. They wanted to talk to him to figure out what is going on, why are you here? Even one of the officers said that. So really what it comes down to, and I asked the court to grant the motion, is that once Mr. Francois was having conversations with the officer, right? He rolled his window down. There was not enough at that point because the state now has to go, because the state can't say, I don't see any case law to support. In the case they use Daniels, it's totally different, right? You have a defendant that I guess he literally stopped at the exit of the parking. That's totally different where Mr. Francois is properly parked in his vehicle and he responds to the officers eventually, not 2 to 3 minutes, 30 seconds. He's responding, he's rolling the window down. At that point, before they open the door, they have to determine that they have a reasonable suspicion to be able to pull him out of the car. At that point, all they had was maybe the odor of alcohol, and the bottle you cannot necessarily attribute to him.
You know what? See, the private counsel is actually doing okay. You know, Yeah, they didn't go all into the SFT, FSTs and how they failed and how they coerced a plan and how they literally made him talk and didn't read Miranda's and did all this interrogation afterwards. But the point, yes, the suppression should be at the point like this private attorney is doing, and he actually does okay. I'm not even going to cap.
So therefore, they did not have the reasonable suspicion to get him, order him out of the car. The welfare check at that point had expired because welfare case law does not say that I'm allowed to pull somebody out of the vehicle even if they're responding to me. That's not that's not the basis. So you really have to look at, did they have, now that I feel satisfied, make a ruling that, okay, at this point, his welfare is established. Now what is the basis for your action, for the governmental action? Which is, now we got to go through the reasonable suspicion standard. And that's where I don't believe the state has met that requirement in order to make someone get out of the car forcibly. And I ask the court to grant the motion.
Do you have anything else? Yes, may the state respond, Your Honor? Yes. Your Honor, in this case, the defendant and his passenger were literally unresponsive for 2 minutes. The officers had been there. And for most of that, the defendant and the passenger were unresponsive. The defendant merely looking at the officers and staring blankly at them as they asked him if he's okay and to get out or to open the vehicle is not responsive, and that's not having a conversation. To say that they're having a conversation is a stretch, Your Honor. The defendant was acting confused and hardly sleeping. Again, after they had been knocking for some time, he lies back down and has to be woken back up. And by the time Officer Cardoso opened the door, he was already noticing signs of impairment and the bottle. The bottle alone is sufficient reasonable suspicion to ask the defendant to exit the vehicle. And it doesn't matter whether or not, it doesn't matter as it's an open container, whether or not it can be, one moment, Your Honor. The bottle alone is sufficient reasonable suspicion to ask the defendant to exit the vehicle. And in the very brief conversation that they had, they noticed the signs of impairment. For those reasons, the state asks that this honorable court deny the defendant's motion to suppress evidence.
All right. Well, the court is going to rely in its ruling on the following case law. I'm going to rely on State of Florida versus Robert Bodrato. That's Bodrato. And I have it here under 47 Florida Law Weekly D1774A. And the court is going to rely on Aaron Ashley Taylor, the State of Florida, which is, no, this is not the Taylor. No, Taylor case.
Oh, whoa. You see how she does that? She goes, oh, wait, no, this is not the Taylor. Well, the Taylor case.
Taylor case, yes. Which is.
Wait, huh?
I have the site here for you. Let me give you the site. I don't have the site for Taylor, but I will also rely on Bromelo.
Oh, I don't have the site for Taylor. See how she just left Taylor out? Why? We're going to go over Taylor in just a second.
Which is 289 Southern 3rd 955. It's a first DCA case. So those are the cases the court is relying on in its ruling. If you need a written order after I say the oral pronouncement, it may be a little different, the words in the written order, of course, but this is the court's oral pronouncement. Officer Cardoso responded to a call on about July 7th of last year of 2 men asleep in a car parked in a garage. He approached the vehicle and attempted to conduct a welfare check.
Wait, she said what? Written orders, of course, but this is, it may be a little bit different. Okay, so what is she, I'm trying to have y'all establish what you're supposed to be, what is on the record and what you owe to. Okay, watch this. We're going to listen to this one more time.
The first DCA case. So those are the cases the court is relying on in its ruling. If you need a written order after I say the oral pronouncement, it may be a little different, the words in the written order, of course, but.
If you need a written order after I say the oral pronouncement, it may be a little different, the words in the written order, of course, but this is the court's oral pronouncement. Okay.
This is the court's oral pronouncement. Officer Cardoso responded to a call on about July 7th of last year of 2 men asleep in a car parked in a garage. He approached the vehicle and attempted to conduct a welfare check, as he indicated, and attempted in doing so to wake up the defendant by knocking on the window and showing his flashlight on the defendant. In attempting to determine the defendant's well-being, Officer Cardoso immediately noticed an open container of alcohol in the back seat, which is an infraction. So at that time, when he approached the vehicle and noticed the open container of alcohol, and in attempting to determine his well-being, as he indicated, Officer Cardoso noticed, as he said in cross-examination, the defendant showing signs of impairment. And he also indicated in cross that after he noticed the open container of alcohol and conducting the welfare check, the defendant was pale, flushed, very confused, and at times of either ignoring or taking a long time to answer his questions. In conducting that welfare check, Officer Lorenzo had reasonable suspicion of impairment, and based on the totality of the circumstances, the motion to suppress is respectfully denied. And the court again is relying on the case law that I indicated, based on the fact that, as I indicated, he approaches, conducts a, well, this is in brief, he conducts a welfare check, Once he conducts the welfare check, he notices an infraction. That infraction leads to the rest of the investigation.
What infraction? He's on private property. What infraction? He's not operating the vehicle. I'm confused on what infraction she's claiming gives them eligibility to intrude. She doesn't. She says an infraction. What infraction?
And therefore it's denied, respectfully.
What? Okay, let me hear this again. This judge.
The court again is relying on the case law that I indicated, based on the fact that, as I indicated, he approaches, conducts this isn't brief. He conducts a welfare check. Once he conducts the welfare check, he notices an infraction. That infraction leads to the rest.
What infraction? You don't get to be vague like that. This is very specific. This is my life, liberty, and the pursuit of happiness here. This is irreparable harm that's been caused to me. What infraction? You said he notices an infraction. How can there be an infraction when I'm on a private property, minding my own business, bro? Sleep.
Rest of the investigation, and therefore it's denied, respectfully.
What?
Okay. Had there been no infraction, case law goes another way, but because there was an infraction, and some cases that I read showed that sometimes the defendant being illegally parked, committing some sort of infraction, and this was the infraction that he was allegedly committing, and therefore that's why the motion is denied. Okay.
What? What? So you're telling me you heard all of this and you literally don't think that they violated Robin's rights? This judge literally believes that there was an infraction that would lead them, after a welfare check, to go violate their rights and arrest them. Man, you is crazy.
Okay, it was a valid stop, not just because of
it was a valid stop.
Welfare check. He did not go as the case law. I have it right here. The case law. The welfare check ends when the need for it ends. In this case, there was an infraction being committed, so therefore he could go this extra step.
What? What infraction? I cannot, bro.
What I don't get is how can he commit a an infraction, and he ain't even moving?
Exactly. He's not operating the vehicle. It's private. Now check this out. This is the Taylor case that she stated, but then she retracted from stating in support of what she was bringing forth. Okay, let's break down the Taylor versus State case. It is a silver bullet for Robin's case. The factual similarities are so identical that under the doctrine of stare decisis, the trial court is bound to reach the same conclusion. Do you hear me? And what that conclusion is suppression of all the evidence. It's crazy that the judge mentioned this and then said, oh, nope, I retract that statement. I can't finish out the statement there because it perfectly matches Robin's, but I'm not going to bring it forth at all. Okay? Because here's the direct comparison of the facts in Taylor versus the facts in Robin's case. The defendant's condition. The defendant was found asleep, unconscious in the driver's seat of a parked vehicle. Robin was found asleep in the driver's seat of a parked vehicle. The vehicle status. The vehicle was legally parked with the engine off. Robin, the vehicle was legally parked in a 24-hour paid parking garage with the engine turned off. The officer's initial approach, the welfare check. In the Taylor case, an officer approached the vehicle to conduct a welfare check because the occupant appeared asleep or passed out. In Robin's case, the officers approached the vehicle to conduct a welfare check, and a security guard reported people sleeping in a car. 4, the constitutional violation, the illegal seizure. Taylor, without attempting to knock on the window, speak to the defendant, or obtain consent, the officers opened the car door. Robbins. As Robin was waking up and attempting to roll down the window, Officer Cardoso, partner, opened the car door without consent, without warrant, and without probable cause. 5, the discovery of evidence. In the Taylor case, after opening the door, the officer smelled an alcohol and observed signs of impairment, leading to a DUI arrest. Robin. After opening the door, the officers allegedly saw an open container and a firearm, leading to the DUI and weapons charges. The court's holding in State versus Taylor. The First District Court of Appeals, right now, this homeboy can go to the District Court of Appeals, bro, and get on this judge's ass for her ruling. Or he could possibly wait and say, you know what? I'm gonna request, like she said, you can request a written order. I'm gonna request a formal written order with depth, right? And You're going to request a formal written order, and then lock her in to her decision. Because on the record, you got her already mentioned in Taylor. So then what can you do? You can bring in a memorandum that goes over the Taylor case in support of a reconsideration or a rehearing. That's what I'm seeing right here in the minutes type shit. So then the first district court of appeal ruled that while an officer can approach a parked car for a welfare check, opening the car door constitutes a seizure under the Fourth Amendment. Uh-oh. The court held that to justify opening the car door during a welfare check, the officer must have a reasonable belief that an emergency exists, requiring immediate entry. I didn't see no emergency. Because the officer... No exigent circumstances, correct. Because the officer and Taylor just saw a person sleeping in a legally parked car and opened the car door without first trying less intrusive means, like continuing to just knock on the window, the entry was illegal. The result, in Taylor, the appellate court reversed the trial court's denial of the motion to suppress, and the defendant's convictions were vacated. Why are we going ahead and filing this right now? Because the appellate court reversed the trial court denial of the motion to suppress, and the defendant's convictions were vacated. We don't even need a conviction on our side. We can go to the District Court of Appeals right now. Why this destroys the state's case against Robin. During the evidentiary hearing, Officer Cardoso admitted under oath he did not have a warrant. He was ordering Robin out of the car, a command, not a request. His partner physically opened the door. He did not see the alcohol or the firearm until after the door was opened. Because Robin was legally parked in a paid garage, sleeping in the car does not constitute a medical emergency justifying forced entry. Under Taylor, the moment of the officer opened Robin's door, an illegal seizure occurred. Therefore, under the fruit of the poisonous tree doctrine, everything discovered after the door was opened, the alcohol, the gun, the officer's observations of Robin, must be suppressed. Without that evidence, the state has no case. So why did the judge mention Taylor and then retract her statement to Taylor, y'all?
Said the quiet part out loud.
Okay? She referenced Taylor, my bro, and then took it away.
She exposed the scam.
That's misconduct. That's the shit I'm talking about all the time.
Big time, dude. Big time misconduct.
Cherry picking like them sausage, right?
Ooh. It's crazy, bro. So we found us a winner here. It's just going through the process. So I don't know, what Robin's going to do is Robin, I think, is probably going to present some of these things over to the private if he's going to keep the private instead of going pro se. But me and him have already built the defendant's sworn motion to compel the written findings of facts and conclusions of law pursuant to the Florida Rules of Criminal Procedure 3.190G and the due process clauses of the Florida and United States constitutions. And one of the mandatory rules and requirements is that while the rule permits findings to be stated on the record, the court's oral pronouncement on December 3rd, 2020, I guess we got to get the date right because it says 2024, but maybe it is, or maybe it was 2025, I'm not sure, failed to articulate specific reviewable findings of facts regarding the timeline of the seizure versus the observation of the alleged infraction, nor did it provide a coherent legal analysis distinguishing the controlling precedent of Taylor versus State, which is in the first DCA, 2021, which the court acknowledged but subsequently abandoned, right? Which we could bring forth in a reference to, the citing of the minutes and the seconds of when she referenced Taylor here in her oral pronouncement. Okay, so as an exhibit. So when you kind of look at it, it's like, what is the private attorney's going to do? How are they going to move? How are they going to shake? How are they going to bake? Because we need to get a written order, a finding, so that way we could possibly move forward with a reconsideration if we need to, right? If we need to move forward with a reconsideration for the adverse rulings based on their factual findings, then we can get that in writing and take that right over to the DCA. I mean, if you wanted to, you could take it right over to the DCA right now. Like, hey, District Court of Appeals, look, I got the court down here making some egregious actions in relation to a motion to suppress when everything is directly related to the Taylor case. I mean, it's the exact same thing. And in the Taylor case, we have to really understand that everything was reversed. Okay, in the Taylor case, the appellate court reversed, and the defendant's convictions were vacated. We don't even want to get to the point where the homeboy's getting the conviction. See what I'm saying? Unless homeboy was to go like dude over in where was that? Montana? Maybe it was in Montana. I forget now. Man, I have to look it up. I have to find it. But the Montana case where homeboy took the conviction but didn't waive his right to an appeal, reserved his right to an appeal, right? What did he end up doing? He ended up going to the appellate court, and the appellate court reversed. Dude got caught with 100 pounds. And they literally reversed everything there. Why? Because the officer sped. The officer violated the law just to get to homeboy. You can't do that based on a hunch with no reasonable suspicion of a crime being committed whatsoever. So there's a lot here. What's up, Dan? There's a lot here that's going on. You know what I'm saying? And yeah, I feel like Robin's got a really strong position if he's able to place the pieces onto the chessboard adequately, or he's able to have his private counsel be able to do such, which I'm not sure that can happen. So yeah, we'll have to see. Or if he has to go pro se, he may have to go pro se. You're at the beach. Oh, that's cool. That's badass, man. Yeah, they look like y'all are lacking a little sun there.
Yeah,
I need a little bit more sun out there, huh, Dan? Just a little bit.
It's cloudy today, but man, it feels good.
Does it feel good? Bet you it does feel good. Want me out on the beach.
Since I got that bond condition changed, I can actually come here and legally.
That's right. Yo, let me tell everybody real quick. My homeboy Dan right here, when he got out, one of his bond conditions was to stay in the fucking county, y'all. He was like required to stay in the county. He couldn't leave. That was his bond conditions. Stay in the county, homeboy. And still nothing's been filed as far as charges against him, kind of like Kane. And homeboy was like, man, I'm kind of tired of these bond conditions, dude. I need to leave, bro. I need to get up out of here, you know? And so we filed for a notice of hearing in relation to the bond conditions. And what happened? What happened, Dan?
Yeah, so I went and met with the magistrate and assistant county prosecutor. And at first they were like, there's no way that they're going to change the bond conditions. But I stated my case and used a lot of the information that Cam gave me and some of my own. And they ended up, well, I told them I was losing multi-thousands of dollars for not being received and work when I was getting called to work, because a lot of my work has to do with traveling and going and playing music. So that's why I'm here today, you know, made some money down here at the beach and I'm enjoying myself. But yeah, so they changed they allow me to travel all throughout Texas now, instead of just the few counties that I had jobs in currently when I was, you know, incarcerated.
So homeboy went in and got him a whole bond modification, right? And succeeded on calling that hearing when nothing was moving. There was no movement with the court. But yeah, homeboy called a notice of hearing, went in there, said, oop, I need to speak on my rights. I need to move around. Y'all need to start doing something here as far as like at least my bond conditions, and got it approved. So y'all just gotta realize, like, go in there and tell them what you want, man, and really like lay it out. And you can get remedy, man. Don't just stick with what they give you. Like, go find the remedy and make the remedy happen. Visualize it, know that it's there, and make it happen. And Dan's a prime example of that. Now, I mean, Andy got a dismissal this week. What's up? Everybody y'all unmute and say congratulations. Dan got a dismissal this week, y'all. Y'all congratulate Dan.
Yeah.
Congratulations, Dan.
Congratulations, Dan. Good job, bro. Thank you, bro. Thank you for doing that.
Congratulations. Way to go.
Thank you so much. Yeah, now I got to figure out my case against them for probably suing them for false imprisonment, whatever else for that first case. Yeah, because these are two different cases.
Yeah, two different cases. Yep. He's
You
got civil
look
suit.
so much. Oh, you look so much happier, and you look so liberated, man. Just going through it, you know who you are now.
All right.
thank you guys.
Yeah, Dan's got. I don't. Have you released that one song yet, Dan?
Say again?
Have you released that one song yet?
No, that's probably not going to come out till June, but you can share it with everybody if you want.
Yeah, I want to share it. I want to share it. Dan's got this cool song that he shared with me, and I guess I'll share it with everybody. Let me see if I can. Hold on, where's it at? Oh, Dan, where's it at? I got it right here by music. Oh, there it goes.
Damn, I play guitar too, man. I've been jamming for 37 years, man.
Cool. Loving the Jamaican vibe.
Maybe we can hook up and come up with something.
How can they call this liberty? Then hand out so much misery.
I like that.
Feeling up their penitentiary.
I like that.
We're members of our family. What's worth fighting for? Freedoms. What's worth dying for? People. What's worth fighting for? Freedoms. What's worth dying for?
See the dismissal, y'all? Look at the dismissal, y'all.
This atrocity.
Yeah, Dan, what's up, Dan? Yeah.
Time for a new policy. Who will fight for equality?
Send a copy of that song to the prosecutor and judge.
Lifting up humanity. What's worth fighting for? Your freedoms. What's worth dying for? Your people. What's worth fighting for? Your freedoms. What's worth dying for?
Yeah, man. Bro, we been jamming this bad boy. We was jamming it yesterday, too. In the car and everything. We was like, what? Let's go, bro. Yeah, bro.
Man, that's fire. Love
Doing
it.
my little two-step over here.
I'm telling you what, yeah, Dan got that fire, yo.
Dan, you didn't say you
Doing
were from
my
Jamaica.
two-step over here.
Where's your CD at, Cam, with KO Beats?
I don't know, bro. I've been so busy. I can't even focus on no music right now. Yeah, we've done a lot. We've been doing a lot of work with Dan. Dan's been getting a lot preserved. I think he did everything on the back end with this next one coming up with Lavernia too. He's already, I mean, like Dan's like going to the, council meetings, like City Hall and stuff. And what, Dan, you just saw the officer recently at like City Hall, right? That did all this to you? Broke your window and stuff?
I saw the cop that busted out my window, and yeah, he was there. He acted like he didn't recognize me, but he probably did. But maybe he didn't. Who knows? Because I was wearing a cowboy hat at that time, when I was being accosted. Well, like those dudes didn't even ask for my ID, and then they charged me with that, and they said I resisted arrest, and clearly I didn't resist. I didn't get out of the truck when they told me to, but they didn't think I was dangerous, and I know they didn't.
Nope, not at all. They knew it.
That would be a big lie.
Yep. That's not going to stick, bro. They can't. Again, we got case opinion that's backing this up here. So, I mean, it's pretty clear, dude. They're, yeah. They never even asked for your ID. It's crazy. So,
Right there, I'll get thrown out the window since they didn't ask for my ID. I mean, that's just insane. I just never thought that would happen, especially in my little hometown.
right. Yeah, the
But as
sergeant was a
long
little.
as your theme entrance coming into that court, and they'll know you're not dangerous.
Facts.
Meetings. It's like y'all see me. I don't even know why they're messing with me, but they were trying to. I think that what was happening is they were training somebody, and I didn't realize at the time. And I started reading the scripts to them, and I just controlled the conversation the entire time. They started to get flustered.
Yep. Yeah. Yeah, I think it was part of training and part of, hey, around here we're going to establish our authority, you know, a little more than anything. And I think at that point maybe the sergeant was confused a little bit on just how maybe he should best approach the situation. And even though he could justify breaking a window in some form or fashion, I don't see how that could truly be justified within the policy and procedures and law, or at least even the colorable law that they have established around through their colorable law opinions, right? Because it's all colorable law, but truth and reality is he should have never broken that because he didn't have a warrant. And infractions are not crimes. So, you know, we get on a base level. I mean, there's so many layers here, but
Yeah, there a lot happened, and I recall that my door on my side was unlocked the entire time. All they had to do was open the door and be like, "Get out! You're under arrest." And I would have said, "For what? You know, why are
yeah,
you?"
yeah, it's a trip. It doesn't make no sense at all.
So
Us, I laughed
the
at
Eddie
him.
Craig script justifies violence.
Yeah, yeah, asking questions justifies violence. You're right, or just even reserving your rights to remain silent to self-incrimination, which is even giving up your name. Apparently, um, you know, it deserves violence, which is exactly what we're fighting, bro. And that's why we need traffic law reform. Yo, check it, man. This has been a really good episode. It's been about 4 hours and 30 minutes. I'm gonna go upstairs and get something to eat, but I'm gonna end the recording for everybody.
Damn.
Yeah, no, it's not. It's not like it has to end. It can continuously go, bro. Everybody has everything they want to talk about and present and whatever. But I want to go to upstairs and get something to eat. But also, I want to end the recording um, for this Operation Wise Dome on Saturday the 18th. So if everybody can just unmute and say goodbye, world, that would be amazing.
Goodbye,
World.
YouTube.
YouTube.
Bye, world.
Join
Later,
Wisedome.
YouTube.
Join Power and Eric the
Bye,
People.
YouTube.
Y'all remember, I am you, we are us, all a part of the great I am. We'll continuously do great things. Yeah, boy.